Same matter, the order has been complied with. 13. 13. What? Judgment dated? The judgment dated 23/1/25. Passing WPC 66 of 2024. In court. Maybe. Item of 39, my lord. 39, he received the amount, my lord. Matter relates to contract payment, my lord. Matter relates to contract payment. Petitioner received the amount, my lord. So it may be close.
Yeah, that. The then counsel on behalf of the petitioner submits that the amount for which the instant petition the claim for the amount for which the instant petition was filed have been duly received, and as such, the petitioner has no cause of action. Taking into account the above, the instant petition stands proof that it has become infructuous.
And it is for actually want to secure this profile.
With the concept of the other side, the applicants item number 24 and 25. Right.
What is the matter about? Regarding the contract and combination of contract. Yes, the personal level, personal difficulty due to class. And so this morning I read part in the contractor. So, madam, this is another statement.
Pay for the
Both the parties seek for an accommodation in the matter. Accordingly, both the petitioners stand adjourned for 4 weeks.
Wait, please, your lordship. With the consent of the other side, I beg to mention item number 43, your lordship. As the senior counsel is in bereavement, your lordship, as the mother passed away.
What do you want?
To accommodate for today, your lordship.
You submitted that is the reading or the learned senior counsel is in bereavement. Such things for an accommodation. It's the matter again on 25th of May.
Obliged.
Item 36, lordship. Engage Mr. M.S. Majumdar, lordship, is not unable to come to court. Engage advocate Mr. M.S. Majumdar. He could not come due to blood. And enter the matter for the one, not 1 day. Well, it was
The
taken from
request of the learned counsel for the petitioner. Matter stands adjourned to be listed on 8th of June. Yeah, what is it?
Lordship, my senior Mr. S. Chauhan is in late, lordship.
What about that? Why no steps have been taken? Make a false statement before this court. Brilliant. This is the matter about a dismissal.
Can we pass over to the
What is the case, Mr. Sharma?
My lord, originally the private respondent and the petitioners are brother and sisters. Now, originally there was a plot of land of around 4 acres and it was for the father. Subsequently, the father married 2 wives and there are the children of them. Now, there was a petition proceeding for extension of the national highway. Subsequently, the petitioner is the son of the second wife. And the second wife had 2 kids. The one expired. So the petitioner mutated his name in respect of the property of the second son. Now, our contention is that since we all are brothers, so we are that are to have been distributed equally. Now,
Has the amount been released?
no, ma'am.
So therefore it has to go on the 384.
No, therefore, my lord, by contenting all this mischief, my lord, it is with respect to one property. In another property also, he illegally mutated that thing.
I'm not concerned.
No,
You are,
only
you are
thing is
not the
that matter-
petitioner.
No, my lord,
No,
because
Mr.
of this,
Sharma, you are not the petitioner here. The question is, if there is a dispute as regards entitlement or apportionment of the compensation, that's decided by the authority under, by the district judge, not by this court.
no, ma'am. The second thing is that, my lord, because of this compensation, my lord, we filed an objection. Stating that because of all this, we filed a title suit.
No,
regarding-
no, no, titles won't go.
Yes, ma'am.
When a
Now
land is
considering that,
required, it has to be done under 384.
now only on the basis that since the ADC has not released the money because of pendency of title suit, they have come up with it.
No,
Only
no,
on that is nothing.
title suit or no title suit, if you want to have a claim out there, this title suit. Yes, what do you have to argue?
Lordship, kindly pass over for the timing, Lordship.
No, no, no. Therefore matters now.
Case 35 is the claim.
2016, how can this matter be pending? Don't take steps and now all these things are going.
Lordship, brief also not with me, Lordship.
Huh?
Brief also not with me, Lordship. The
Don't
senior-
argue. Then none appears for the petitioner, we dismiss it for default.
Lordship, kindly pass over for the timing, Lordship.
Absolutely no. Get hold of your senior. Okay. Let the senior come.
Right, Lordship.
Where is the watch? Yes. By 11 o'clock, ask him to be here. For a dismissal.
I have already given the new address for the section lordship.
Where?
Lordship 4/11/2025 as per amendment of the first title lordship.
What did you give? You took steps
Yes, lordship.
upon the respondent number 5.
Yes, lordship.
Then,
Already I have taken lordship.
So
This is the petition lordship also I have given peruse you lordship.
what is this?
As per direction of the Honorable Court 7
Huh?
Respondent of 5 lordship.
No, 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 no. Why don't you appear before the Lozima court when the matter is called up?
That was the time I have not seen lordship Lodima court listed lordship.
Why?
That is why.
It has come twice. You have never appeared.
That was the time I am out of station lordship.
So,
I am very sorry lordship.
so we impose a cost of 5,000 upon you. And appear before the Lozima court.
Lordship, I am very sorry lordship.
No, we strike out the respondent number 5.
Already lordship, I have taken.
Sorry, we impose a cost upon 5,000 upon you. This is not done.
Lordship, I am very sorry lordship. I
There's
have,
nothing to be sorry about. Impose a
lordship,
cost
I
of
have
5,000.
already taken step lordship
No,
11.
you have taken
11
steps, you have taken steps in a wrong address. It has come unserved. Then matter came up before the Lozima court on twice. You did not choose to appear. That is why we have the matter before us.
That was the time I have
You are
lordship
not interested in pursuing with the matter.
out of station lordship.
No,
That
no,
is
no,
why.
I
lordship.
think we should dismiss
My
it.
colleague is also,
Yes, what is this case, Mr. Burua? What is your case? Let us see. What is your case?
lordship non-payment of the contractual bill.
By
Non,
who has not paid?
lordship,
Who has not paid?
National Highway Authority, Lord.
Okay, National Highway has filed an affidavit. What is that? You are a subcontractor
Yes, Lord.
of the respondent number 5.
Yes, Lord.
So it's a dispute between you and him. Why should we entertain this type of petition? Go before the civil court. Oh, indeed. Isn't it? He's not recognized because a subcontractor has to be recognized by the NHIDCL. Have you been recognized? There is an order being passed when a subcontractor is being appointed. There's an order being passed by the competent authority saying that he is a subcontractor, he will be recognized. You are not recognized.
Lordship, this Honorable High Court also passed an order, Lordship, similar matter, Lordship.
Where?
This Honorable High Court also passed a similar order
Regarding,
similar matter, Lord.
you saw it before the division bench?
Yes,
We-
Lordship.
That this is, they hope,
This is the division bench order, Lord.
let it be, show it before the division bench. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. C. Borwa appears on behalf of the respondent numbers 1, 2, 1, 2, 4, 1, 2, 4, 4. PWD. You are paying for PWD. None appears on behalf of the other respondents from court. The instant writ petition has been filed by 3 contractors. First of all, why should 3 contractors file 1 petition?
Lordship,
You get hold of all the hundreds of contractors who have not got any money and then file 1 writ petition. Better off.
already I have all the petition alert. Petitioner number 1, RP Technical, and petitioner Pradeep Kumar Datta, second representative, DK Construction, Lordship.
So the petitioners herein have filed the instant writ petition claiming a direction upon the respondent numbers 2 and 6 to make payment of the outstanding bill amount of rupees 30,06,828. It is the case of the petitioners that the respondent number 6 was allotted the work by the NHIDCL. The said respondent number 6, it is claimed by the petitioners that the said respondent number 6 thereupon gave a subcontract to the petitioners by entering into an agreement on 1/6/2017 in respect to supply of excavator, power generator, power board, welding, rectifier, fabrication work, etc. And for construction of the 4-laning of Jhansi to Demo section of NH 37 from kilometer 520 and kilometer 530 in the state of Assam. It is the case of the petitioners that the petitioner have thereupon submitted bills to the respondent number 6. to the tune of rupees 34,44,241. And the respondent number 6 have only paid an amount of rupees 4,37,403. Further to that, an amount of rupees 30,06,828 was claimed by the petitioners against the respondent number 6. It is on account of non-payment of the said amount of rupees 30,06,828 by the respondent number 6. The instant writ petition has been filed seeking a direction upon the respondent number 2 and respondent number 6 for payment of the dues. From a perusal of the materials on record, there is nothing which would show that the respondent number 2 or the respondent number 4 had any privity of contract between the petitioner with the petitioner. An affidavit has been filed by the respondent number 2 and 4. Wherein it is categorically mentioned that paragraph number 4 that the respondent number 6 is not the approved contractor or subcontractor of NHIDCL. And the NHIDCL is only liable to pay against the executed work only to the EPC contractor as per the provisions of the agreement signed between NHIDCL and EPC contractor, that is the respondent number 5. It is also mentioned that if the respondent number 5 had engaged the respondent number 6, the NHIDCL had nothing, were neither aware of or has any liability against the respondent number 6 in liability towards the respondent number 6. To the said affidavit in opposition, the contract document between the NHIDCL and the respondent number 5 have been enclosed. An affidavit in reply has been filed by the petitioners to the affidavit in opposition filed by the respondent number 2 and 4. And nothing would be shown in the said affidavit in reply that the petitioner had any contract with the NHIDCL to claim the said amount. The above materials on record therefore clearly show that it is purely a private dispute between the petitioner and the respondent number 6, if any. And in that regard, the petitioner had and such disputes cannot be permitted to be and such disputes cannot be adjudicated . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . in a public law remedy, by way of a public law remedy, that too when the respondent numbers 1, 2, and 4 have no correlation with the petitioner. Accordingly, this court does not find any ground for entertaining the instant writ petition for which the writ petition stands dismissed. This goes further. Now, before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not preclude the petitioner to approach the competent court of civil jurisdiction, if so advised, claiming any dues against the respondent number 6.
Alia.
What is this? Why the matter has come?
Lordship may perish the last order dated 18/2/2026.
Even made
My lord, February last occasion, my lord, I had submitted a fresh fund demand was submitted. And my lord, I'm just praying for some time to get updated status. Otherwise, the entire fresh fund demands papers I have with me, the offices were closed with this. So my lord, I'm just praying for a week's time to get the updated status.
so long time back.
Yes, my lord.
18 to we are almost in 18 after 2 months have gone, nothing has happened.
My lord,
We have
so-
already verified it. There was a direction to pass the order on 2020. 6 years it has come. Okay, you pay along with interest. Along with interest. And interest will be deducted from this hearing officer. This is an application filed alleging willful and deliberate violation to the order dated 12/2/2020, passed in WPC number 5051/2019. When a matter was taken up on 18/2/2026, the counsel who represents the contenders have categorically made a submission before this court that the petitioner is entitled to rupees 4,74,112 and due process for payment was also initiated. This court specifically fixed the matter on 10/4/2026 at the request of the counsel who appeared for the contenders as regards the status of compliance. So today, when the matter is being listed, no instructions is available upon. Instruction is available with the counsel appearing on behalf of the contenders, which clearly suggests that the contenders are not taking up the compliance to the order passed by this court on 12/2/2020 in WBC number 5051/2019 in right earnest. List this matter again on fourth of May 2026. In the circumstance, the amount is not released to the petitioners on or before the next date. This court would be constrained to initiate contempt proceedings against the respondent numbers 1, 2, and 3 for non-compliance.
Our name is not shown, but it pertains to my lord PHE. I have received some instructions. I would like to place it on evidence.
The Ibotakur appears on behalf of all the contemners.
On behalf of PHE.
What PHAP? In the contempt petition. Appears on behalf of the contemners numbers 1, 2, 3, and 4. And submits that he would be filing their reply within 10 days. List the matter on 6th of May 2026. The response of the contemners be filed on or before 4th of May 2026.
PHE's name may be reflected.
What PHE name?
Or my name.
The name of Mr. Ibotak will be reflected in the bond.
Excuse the lordship. Lordship, we have taken step. Lot of services awaiting your lordship.
Service being complete in terms with the order dated 24/3/2026 of the Lozima Court. Lists the matter for admission on 11th of May 2026.
Highly obliged.
Here, Here, when a case has been filed on the opinion of my appeal of the petitioners, my lord, they have admitted. If your lordship notices, my lord, please.
Lordship,
Yes, for-
in this matter, Lordship, we have received exception, Lordship. The petition party decided to pay the pending amount of the petitioner when the fund is available. When the fund is available.
How much?
My lord,
40 lakhs, 35.
2 crore 40 lakhs, my lord, and another, my lord, there is a SD money, earnest money. Performance security earnest money available. Your lordship kindly put my lord, paragraph 6.
Is your contract document?
Yes, ma'am. Lordship kindly come to my lord, page 38, annex 7.
It is mentioned out here that if the payment would be made upon availability of funds. No, not your instructions in the contract document. Huh? The service being, you find out. So you have not filed the affidavit also.
Yes, sir.
Why?
Lordship, this instruction is on 17 April, Lordship. Simply file it.
No, madam, we are not concerned when you receive it. Question is out here When there is a direction passed by you to file your affidavit, you have to file. You have not received your thing or you don't want to file, you say that you are not going. You won't file it. You say that you are not going to file it.
No, no, Lordship, we file
Then why you are not filing it?
short accommodation laws. Next time.
7 days. 7 days, not more than that. In terms with the office note dated, in terms with the order of the laws in a court dated, in terms with the office note dated 27/1/2026, the service is complete and accordingly lists the matter for admission on 4th of May 2026. A final opportunity is granted to the BTC to bring on record its stand by filing the affidavits on or before 30th of April 2026. This is the matter for admission.
Lordship, I have submitted the amended post level lordship on master council lordship. For respondent number 6, lordship notice may be rolled out. No, respondent number 6, lordship. New implemented part.
Service complete.
Service complete. Lordship, no notice has not been issued yet, lordship. Only
Upon
upon respondent number 6, lordship. Newly implemented.
Puji. Where is that?
Yes, lordship, this is the IA order, lordship, correct. On 7/3, lordship, I have submitted.
Heard Mr. J. Abbas, the learned counsel for the petitioner. Uslo. It is seen that by an order dated 25/2/2026, the respondent number 6 was amended, was arrayed as a party to the instant proceedings. However, no notice was issued, taking into account that the presence of the respondent number 6 is necessary for the purpose of proper adjudication of the present dispute. This court issues notice upon the respondent number 6, returnable by 22nd of June 2026. Steps be taken upon the respondent number 6 by way of speed post by tomorrow. In addition to that, the petitioner is being granted the liberty to take steps by way of dusty to take to the registry of this court and file an affidavit of service on or before the next day.
Obliged, lordship.
Huh? Actions complied? Where?
Get the instruction.
Where is the order? Is it the contempt or a requisition?
Contempt.
Where's the contempt? Is the direction? The direction to pay the petitioner the bill amount within a period of 3 months from the date of receipt. You paid the money. Where is it? None appears on behalf of the petitioner on call. This is an application file alleging willful and deliberate violation to the order dated 27/5/2024, passing WPC number 5194 of 2023, where there was a direction upon the respondent authorities to pay the petitioner the bill amount of rupees 12,70,601 within a period of 3 months from the date of receipt of the copy of the order. Mr. J. Abbas, the learned counsel who appeared on behalf of
Yes,
the.
what about? Yes, what about? Yes,
What?
one and two. Respondent
Well,
one
as Botaku.
on behalf of meeting as what about?
No, you don't appear for as Botaku.
Respondent number one and two.
Mr. J. Abbas, the learned counsel who appears on behalf of the respondent numbers 1 and 2 submits that the said amount of rupees that the petitioner have been already paid, the amount of rupees 11,41,387, which is the amount payable after deduction of tax by the check number 784410 dated 26/9/2025. In that regard, he has placed before this court an instruction dated 30/10/2025, which is kept on record and marked with the letter X, taking into account the above, as the order dated so and so, passed in WPC number so and so have been complied with. The instant contempt proceedings that's strong.
Item 9 and 10 was same. Same.
These are the other two persons. There are three persons. No?
Same person. Same.
But this is 7,51,000 and the other is 12,48,000. A first page come to you. Who's it? First page come to you. Next. You come to you.
The petitioner received his money, Lordship, the order is complied with.
Huh?
Page 13 is the order, Lordship. He received all the money,
Complied.
complied, Lordship.
Where is that order?
Page 30.
On payment.
Lordship.
Heard Miss So and so, the learned counsel appearing on behalf of the petitioner. Miss R. Deca appears for
3, 5 and 6.
and Miss A. Gayan appears for 1.
4 also, you know. 2 to 6, I am appearing.
This is an application filed alleging willful and deliberate violation to the order dated 4/3/2024, passing WPC number 1265/2024. It has been submitted by the learned counsel appearing on behalf of the petitioner that the petitioner have received the entire amount. And as such, there is nothing, and as such, no, it is submitted by the learned counsel appearing on behalf of the petitioner that the order dated so and so, passed in WPC number so and so have been complied with. Taking into account the above, the instant contempt of proceedings stands closed. What is it?
Order is Lordship at phase 10.
Complied, not complied.
Lordship, verification process is going on, Lordship. That one direction was given by this court to verify the claim of the petitioner, Lordship. And they want some time to complete the verification process because the earlier committee was dissolved and next.
Order was passed in 2024. Does it take such a long time to verify? I'm not concerned about payment. Payment will be made as per Tamserali, but what is this amount he is entitled to?
That's verification. After verification, this.
Where is the verification? Does it take 2 years for you to verify?
Lordship, they have tried their level best and the committee was dissolved, Lordship. Instead
I'm
of-
not concerned with that. My question is, does it take 2 years for you to verify?
Not,
Then tomorrow,
no, Lordship.
day after, verify, give us the date. You can't do it like this. Thereafter, you give us the how much is the verified amount, and we close it. You pay as per terms and all. But why it is that you are not being able to verify?
So kindly peruse, the order, Lordship,
What is there?
10 page 10.
Uh,
Last paragraph, as it was not clear whether the claim of the petitioner is admitted, other time was granted by this court under its order dated since permitting the response to file a special. Subsequently, an affidavit has been filed for the respondent secretary of BPC who has taken the following stand in paragraph 4 and 5. The definite basis insert of central tax warehouse BPC file data dated since submitted a tabulation of various items received from Messrs. Bosumotari Enterprise, Bandurguri, for all government and non-government officials of 4 districts of BTC, including BTC Secretary for COVID-19 crisis related supply. They have supplied certain materials. Lordship. Further, the deponent begs to see that the petitioner's claim is being examined, and once process is complete and found eligible for making payment, the decision will be taken in the light of direction of Tamsera Lordship. Hereafter, they have uh, a committee was constituted for examining the veracity of their claim, whether they have supplied the these materials. And thereafter, Lordship, this secretariat, this committee was dissolved as the same government was changed. Now, a different committee was constituted, and thereafter, Lordship, this election conduct of this Lordship.
What are they doing
One
in
more
the
time,
election?
Lordship.
What is this committee doing in the election? Election will happen only in the month of April,
Yes, Lordship.
and model code of conduct came in the month of March. But this order is of 28/8/2024. Then
1 month time, they are praying
You're
for
sleeping.
complete
you
process.
are sleeping. Because committee is
Lordship,
usually.
two governments is doing this.
I'm
That's what-
concerned
1 month,
with the,
that's kindly-
whichever is the government, I'm not concerned. You are sleeping, means you're not doing it, means you therefore admit it. We
Does
get you, how much amount?
That amount is not being.
That is
Sir?
clear, Lordship. So this
That is why, after considering all lordship, it was direction to
very.
verify lordship, verify the claim lordship.
Understood, but what is your claim?
That amount was not.
Then how can they verify?
Records will be available with the.
You don't know how much you have supplied. This order cannot be complied with.
See, after verification, after considering
This
everything.
order cannot be complied with. Sorry. We close this contempt on the ground that this order cannot be complied. How can there be a direction on to verify in the beginning? There's not a single statement made how much you have claimed.
Then lordship, day after tomorrow.
We close it. That of order cannot be complied.
After some time.
First, Mr. J. Abbas, the learning counsel, is hearing on behalf of the petitioner. Ms. Ken Chaudhary appears on behalf of the respondents. This is an application filed alleging willful and deliberate violation to the order dated 28/8/2024, asking the petition number 1770/2022. A perusal of the said order shows that a perusal of the order dated 28/8/2024 show that the petitioner, claiming that he had supplied materials to the respondents at different healthcare facilities during the COVID pandemic, sought for certain directions for payment. There is nothing mentioned in the order dated 28/8/2024 as to what is the claim of the petitioner. On the other hand, the respondents have also filed an affidavit to that effect, stating entirely before the in the writ proceedings to the effect that the in charge of the Central Drugs Warehouse BTC had submitted a tabulation of various items received from the petitioner for all government and non-government officers of 4 districts of PTC, including PTC Secretariat for COVID-19 crisis-related supply. But there is no indication regarding the rate of items. It was further mentioned in the said affidavit that the petitioner's claim is being examined and once processed, and once the process is complete and found eligible for making payment, the decision will be taken in the light of directions passed in Contempt and others versus the state of Assam and others reported in 2008 OGMP 1. The learned court bench by the order dated 28/8/2024 directed the petitioner to submit a representation to the principal secretary BTC stating its claim and directing the principal secretary BTC thereupon to verify the amount claimed by the petitioner and if found admissible to make payment. This court had perused the representation which was submitted by the petitioner on 5/9/2024, wherein also there is not a whisper as to what is the claim amount of the petitioner. Under such circumstances, as the petitioner have not stated what is the claim amount of the petitioner in the representation, the question of there being a willful and deliberate violation to the order dated 28/8/2024, passed in deputation number so and so does not arise. Accordingly, the contempt proceedings stands.
Worship, their affidavit is declared that they have admitted that there is supply
Division bench.
of less.
None appears for the petitioner on call. Mr. H.K. Sharma appears on behalf of the respondents
6 to 70.
6 to 7. It is also seen that the petitioner has also not taken steps for service of notice upon the respondent number 4 in spite of various directions passed by this court as well as by the laws of the court. Considering the above, it therefore appears that the petitioner is not interested in proceeding with the instant proceedings for which the petition stands dismissed on proceeding. Be that as it may, before parting with the report, however, this court observes that the dismissal of the incident with petition shall not preclude the petitioners to approach the appropriate authority in terms with section 3H4 of the National Highways Act 1956 if so advised.
Well, the service is complete here. So. Should I fix the hearing? I will file a PDFA in the meantime.
Huh?
I will file a PDFA.
What is this matter? Come up for admission?
Not orders.
What is the order?
Well, I would like to take.
Okay, service is complete.
Service is complete.
The service being complete lists the matter for admission on 15th of May 2026. In the meantime, the official respondents were ABC or
No, sir, Fishery Department, Fishery Department.
the fishery department is given a final opportunity to bring on record its stand by filing the affidavits on or before 11th of May 2026. Let's see.
Well, your lordship allows me. Your lordship will find that by order dated 18/6/2025, the honorable court passed an order to, well, to what steps the SP has taken, my lord, in the affidavit, they did
Let
not
us
say.
come up for admission on 15. All the official respondents are given the final opportunity to bring on record and stand by filing the affidavit on or before 11th of May 2000.
Oblige, sir. Oblige.
It's the matter for admission, taking into account the office note dated 18/3/2026 on 18th of May 2026.
May I please, Lordship? Lordship, in this matter, I have received instruction today, my lord. I need 7 days time to file my affidavit.
What is this?
Look, in item number 17, will I appear for the petitioner? Lord? It was with regard to settlement of Lord, tender process with regard to shops, my lord, under Algapur Gao Panchayat. Now, my lord, we were my lord, selecting the tender process, therefore the possession was not being handed over. Therefore, we filed this case. In the meanwhile, possession has been handed over. But some people, my lord, has been raising some grievances with regard to Lord, alleging my lord, that they were selected, there were some selected candidates.
Anyway,
They
the
were trying-
service is complete. Service is complete, so we let us have all those matters on a particular day for admission.
Bishop.
And in the meantime, you file.
I'll file. Yes, yes.
In fact, I will also file my affidavit, item number 16. Yeah, item number 16, I will file my affidavit.
Okay. From the office notes, these are from the office note. In the petition number. From the office note dated, from the order of the Lodgement Court dated 11/3/2026 in WPC number 205/2026. It appears that the service is complete. Accordingly, all the three petitions are directed to be listed again on 22nd of May 2026 for admission. In the meantime, the respondents, the official respondents, who is being represented by Mr. S. Dr. shall bring on record their stand by filing their affidavits on or before 19th of May 2026. Mr. M. Dr., who appears on behalf of the respondent in
No, 7, in the 20526, madam.
Huh?
In WPC number 20526, madam. In for respondent was 7, 10,
you are appearing for the respondents.
there's not all, madam. 7, madam, then 10 to 13 and 15 to 19, madam.
In one case, he is a petitioner
In
in
one
17. In other case,
In 16, I am the respondent, I am for the respondents. In 17, they're the same person, madam, they're the petitioners, madam.
Mr. M. Dr., who appears on behalf of some of the private respondents in some of the private respondents in the petition number 205/2026 shall also bring on record their stand of the respondents, private respondents on or before 19th of May 2026.
my lord.
put your name equal. Once we get printers having a golden ink, we'll print it out.
Wait, please, your lordship.
What is this?
Lordship, this is an,
I have Kajan. Kajan Cement Corporation. What is wrong with it? Condonation of delay.
Lordship,
Dismiss for default.
dismiss for default.
Why?
Lordship, earlier it was restored, but on that, after restoration, when the matter was on call, that my name was not reflected. Newly against, council's name was not reflected. So, not appear before your lordship.
And
So that was, therefore, the case was dismissed for default.
then?
Thereafter, we have filed a restoration petition,
Ah,
which was delayed in 29 days. When we come before the registry lordship to list the matter, then come to know that that was dismissed for default. So they are
50,000? 50,000 question. Because this is the second.
is actually old, but so
Who?
the Bukadon Cement Factory.
No, no, not on them. Upon you.
Lordship.
Upon you. It's your fault. Because glaringly shown in the first list.
Lordship,
RP Thakuria, what's your name?
SRA Nasir lordship.
Go. LP Sharma, R Thakuria, their names are there.
Lordship, he is actually the LP Sharma sir was died lordship.
There. Who is R Thakuria?
Article is not our team lordship.
Then why did you have your name? Who filed the application for, this one? It has come up for admission on this particular date. Then again, it came up again on some other date. We are not allowing this type of thing. And what is your case? Argue on merits. Because I remember this case. I wanted to dismiss when Mr. J. Roy was there on the other side.
Lordship, this was, this is the different case lordship.
This is the case.
That was
What
the,
is your case? Argue your case.
in this matter, this is the order.
Challenge is made to the no dispute award dated demand passed by the demand reference as order wherein the application made by the EA for vacating the ex parte awards to be dismissed. Okay, then you're not interested. What is your case?
But the industrial, we are filing this writ petition against the order of the industrial tribunal.
Ah.
And when as a secretary, general secretary of the Bukadon Cement employee Bukadon Cement Corporation Employees Union, I could not appear to cross-examine due to my medical illness and my mother's medical
But the award was, arguments were heard in the party.
lordship. But
Then why ex parte? Why do you say there is no dispute award?
there are 64 chartered.
What is there? From the above here, I am of the consideration that we have failed to show sufficient cause which prevented him from attending the tribunal as so and so. As such, the petition for setting aside the award dated so and so. This was setting aside the award. Where is the award?
Lordship, number.
Huh?
Order.
Where? Where is the award? Now tell me one thing. This is a reference. This reference happened in 2013 in respect to something which happened in 2010. Okay. Is the industrial dispute still alive?
Uh,
Reference was made in the year 1991.
As per my instruction logic, the employees union have submitted some representations before the Ministry of Labor and also sent a representation to the PMO office also, but which are not, which are still pending. So therefore, maybe one chance can be given by.
No. These are something of a strike in the year 1991. That has already sailed. Now, whether the action of Mukazan Corporation Union in raising the demands before before the general manager is justified, that has also sailed the boat. You can very well make fresh demands. What remains? You see, we are, as of now, 36 years, not 36, 91. These are letters written in 1989. 89. Today is 26. 26 plus 10, 36, 36, 37 years old. What remains here? Kindly see page 26 of the petition. Nothing remains. Therefore, there is no dispute. No point. Then whether the strikes resorted to by the workmen of the aforesaid cement factory on so and so and so and so one day are legal and justified. What happened thereafter? It may have been said to be unjustified. Then any further consequence? Then we do one thing. We condone the delay, do everything, and dismiss your petition.
Lots of things.
Do-
If they dismiss it, but dismiss for default is on our part, so logic.
Plus, impose a cost of 50,000 upon you. Don't forget that. Your fault. Because keeping this matter pending is no point. Problem lies there, na, Mr. Counsel. Though there is no delay, there is no requirement of this, so with petition, there is no delay in filing a restoration application. But the thing remains out here that without issuing notice, I can't do that. But we don't have a case. Issue notice, making it returnable on 18th of May 2026. Steps be taken by the petitioner, Miss So and so accepts notice. Mr. Union, any council union? Mr. H. Gupta. Mr. H. Gupta accepts notice on behalf of the respondent number 1. Ms. Udas accepts notice for respondent number 2. As regards the respondent number 3, liberty given to the counsel for the petitioner to serve upon the counsel appearing on behalf of the respondent number 3 in the writ proceedings. Steps be taken within 3 days. List. We dismiss it on that way with 50,000.
May I plead the lordship? My lord, hope it not reflect that the service upon the private telephone number 7 and 8 is complete. My lord.
What is the work?
My lord, it is regarding a tender of a road construction, my lord. Where my-
PWD.
Yes, my lord.
We have received instruction, we will file affidavit.
My lord, issue is that my lord, tender was issued by the respondent number 6. So petitioner was adjudged as L1, my lord. Subsequently, my lord, the private respondent 7 and 8, they filed some representation. Because my lord, they were adjudged as non-responsive, respondent number 7 and 8. So they filed representation. And those representations were duly considered by the respondent number 6 and duly constituted standard evaluation committee. Subsequently, they again approached the respondent number 2, my lord, Ministry of Road Transport, my lord. And subsequently, the impugn order was passed by the respondent number 2, thereby cancelling the entire tender process, my lord. Whereas, my lord, he is not empowered to do so.
Why do you say so?
If your lordship peruses page 56, my lord. Clause page 56, clause 30.1, my lord. Page 56. Clause 30.1. Notwithstanding clause 29, the employer reserves the right to accept or reject any bid and to cancel the bidding process and reject all bids at any time prior to the award of contract, without thereby incurring any liability to the affected bidder or bidders, or any obligation to inform the affected bidder or bidders of the grounds for the employer's action. So here the employer is the respondent number 6.
How do you say respondent number 6 is the employer?
My lord, it is there, my lord.
Where? Employer has been defined somewhere?
Yes, my lord, it has
Where?
been defined in the yes.
Where?
My lord,
They are not prepared, we dismiss your petition.
no, my
No,
lord,
I'm saying you are not prepared.
I
This
have
is
drafted
the-
the entire petition,
You
my
don't
lord.
require an affidavit. Then you're not prepared.
No, I am prepared.
Are you?
Cancellation was done by respondent number 6. In fact, page 289. 289, yes, no. Cancellation was done by 6, not by 2.
What is the-
That is in terms of the order.
Obviously, they have the power. That is under them. No, we in that case. We
No,
dismiss.
page 286
We are not
is
going to break it. We are not going to extend the interim order.
Page
Not
two-
satisfied.
Page 286.
Interim order is till today, na?
Page 286 is the impugn order, my lord.
The interim, only today. I'm not extending.
My
the-
lord, page 286 is the interim order, impugn order, my lord.
Which?
Page 286.
No, show me that he has no power. Cancellation has been done by the chief engineer. He is only the authority.
Yes, my lord.
Authority is different from employer.
But he did not issue
No,
the tender. He did not have any authority to cancel
What do
it,
you
my
say,
lord.
Mr. We should dismiss it.
No,
No, no.
and secondly, my lord, last tender evaluation committee meeting, my lord, they have duly considered their representation.
We cannot stop this tender process from going ahead because of the fact that first tender, who is going to pay? Give an indemnity bond for any escalation which happens on account of this, you are going to bear. Even indemnity. Bank guarantee, not indemnity. What do you say, Mr. Nayak? Bank guarantee? Page 67. Yeah. Then
Where is the ITB? And defining the appendix to the ITB. Where is that definition? Where is the appendix? Here, page 62.
Yes,
The employee, the chief engineer, PWD. So, what is wrong? He has cancelled it.
he has not cancelled it. Respondent number 2 has cancelled it, my lord.
Oh, the cancellation is been.
Cancellation in pursuance of the order passed by the ministry, my lord. We have basically challenged the order passed by the
Mr.
ministry.
Bora, nothing. The fact remains out there very clear. The NH division of the state
Yes,
works under the aegis of the ministry.
yes,
What? What has the overall power?
yes, my lord.
And therefore it is being cancelled through him, the employee itself. But overall, the MOT has the superintendence.
288, ma'am.
So what?
So it was cancelled by the respondent number 2, my lord.
So what?
He is not empowered, my lord, as per the terms and conditions, my lord.
No, he is signing on behalf of the director.
Yes, my lord. Even the director is not empowered, my lord, because the employer is the, has the
The
authority.
money has been sanctioned by MOT. This has to be done in respect to it. I don't think.
And my lord, kindly see the order on what basis they have cancelled it. Because the representations filed by the respondent number 7 and 8, my lord.
Maybe.
That has been duty considered by the bid evaluation committee, my lord.
They have the overall power. What right do you have? They have a good reason for that. You don't say on the
But
basis of-
in them, they justify, my lord, on what basis they have cancelled it. Because, my lord, because.
They have given a law order.
No, my lord.
Yes. Ministry circular dated so of permit seeking and seeking considering the gravity of minor procedural deficiency that too do not alter the basic character of the offer and do not result in material change. The circular, these are all repeating of bids, houses on observable record noted that the issue of treatment of minor deficiencies and the approach of suiting criteria was raised both during the evaluation process and through representation with specific reference to the ministry circular. The students it is further observed that the labor license requirement as per its placement and execution showing. The decision has examined the students.
Taken cumulatively,
My lord, that representation dated 3/1/2026 and 6/1/2026, that has been already duly considered by the bid evaluation committee, my lord. That has been already considered
The
by.
order clearly says, my lord, taken cumulatively, these aspects indicate that the tender process does not inspire sufficient procedural confidence and warrants cancellation in the interest of transparency and adequate competition.
You don't have the fact. You see, the PWD has no business out there. It is done under the aegis of the Ministry of Transport. They are doing it. PWD has no business out there. They are just the executing agency. So, therefore, why you are having the more people out? If it is the way you are the CPWD has the PWD has all the.
That bid evaluation committee.
Mr. Nayak, your PWD have done all these things, but anyway, I think this is not a we should do the thing. Okay, for me, this is by the authority will.
The power is delegated, my lord.
Be the minister, they are to the so and so agency. So delegated, so what? They have the power.
But my lord, that
Do
power.
you see that, do you say that the ministry has no business out there? Delegation of power to the chief engineer, regional, so and so. We should take a- Yes, I think we have a. What is the value of the work? More than 5 crores. Huh? More than 5 crores. 40 crores. 40 crores. Indeed. Yes, madam. Maybe more than 5 crores. 40. Number 8, Manoj, evaluation with. Point number 8, Manoj, is evaluation of bid in case of work sanction, Manoj, more than 5 crores to 100 crores. The chief engineer NH, Manoj, would be the chairman, who comprise of the following committee, Manoj. Representative of the State Finance Department, officer nominated by the MOT, superintending engineer and executive owner. Okay, you highly affiliate because here is the question of reporting. But you want the intent order to be extended, then you have to give an indemnity that whatever extra amount is to the air, you are to pay.
You're not, it's a short date, my daughter, be like a short time, it may be taken up. my
No, no, no. You want an extension. I'm not going to extend it without the. Even indemnity, then I give you only 4 days for driving an engine. Making any
Then it will be put out for it.
before this court,
Court, madam.
that in their circumstance, so and so,
there's a delay, you lose the case, you're going to pay.
For other method, they spot this will fix method, they will file the affidavit in a short time method, you will take up.
No, but why should I give them information? Interim orders, if I'm giving you, you have to go. Hey,
The next date method.
in the next date also, you have to give me 4 days. I give you a 4 day period. Even intent, the intent will continue to probate subject to you furnishing a indemnity cost. That in the circumstance that you lose the case and there is an escalation, you have to pay them down.
But you're not to fix a short date, let them file the affidavit in a short time.
I'm fixing it on Friday. You won't file it, you will file it by tomorrow, we'll file it. It's ready, Malad. You file it. No, you don't have, you say anything, you file a petition. You have no book, otherwise go under 131 before the Supreme. No, it is the case. What, no, if you want to see your authority, if you are trying to contradict your stand, which has been given by the chief engineer, you are at liberty to do so. Then ask him to recall that notification. He has done this particular document. No, Mr. Naik, this is not done because of the fact that this particular cancellation has been done by your chief engineer. Whatever may be, he have accepted it. You cannot say unless you are holding the brief for somebody else. If you are holding the brief for PWD, you cannot say that you do not recognize the authority of the central government because your person have accepted it. The moment you say something, well, one can very well take up a different note as to on what basis you are making the submission. Because unless you cancel it, you withdraw this cancellation notice. Without withdrawing the cancellation notice, or you file an affidavit saying that this cancellation notice is not good. So otherwise, no, Mr. Naik. And if you want to support him, support him. If you don't want to support him, then it's a different thing. Then you have to file an affidavit saying that he has no authority. File an affidavit. Tomorrow, what will you know the consequences which will befall upon you? All the NH division will stop. Mr. H. Gupta, the learned counsel appearing on behalf of the petitioner, respondent submits that the affidavit will be filed on behalf of the respondents by tomorrow, by the mort author, by the respondent. Numbers 1, 2, 3. Tomorrow. Huh? 4, you are 4, huh? 1 to 4 tomorrow. You are going to file a reply?
If required, my lord, please, I file.
Mr. D.P. Bora, the learned counsel submit, appearing on behalf of the petitioner submits that we would file the reply by Friday. List the matter again on April 28th, 2026 at 2 p.m. for final disposal. Interim order passed earlier shall be stands extended only till the next date. Interim order passed earlier shall stand extended till the next date, subject to the petitioner submitting an indemnity bond before the registry of this court by Friday, to the effect that in the circumstance there is any escalation on account of the interim order passed by this court, the petitioner, and the petitioner is unsuccessful in the present proceedings, the petitioner would bear such expenses.
Yes. Or not been complied with by to the current application.
We have applied with manner, he took sign. My love, I know this to go. States first.
Yes, Mr. Solia. Your case has become infectious. Is that clear? But Mr. D.P. Solia, the counsel is straight by solution on behalf of the chief, which you guys appears on behalf of the numbers.
All my.
All the respondents, huh?
My.
On respondent numbers 1 to 5. The petitioner herein, who was issued the PDS license have approached this court seeking directions upon the respondent authorities to comply with the order dated 11/12/2019 passed by the learned commissioner of the Central Assam Division. The brief facts which led to the filing of the instant petition are that the petitioner's license was cancelled by the additional deputy commissioner, Nauga, by an order dated 10/10/2018. On the ground that the petitioner had violated clauses 10, 14, 18, and 26 of the Assam Public Distribution and Articles Order 1982, as well as the terms and conditions number 3 small a, small b, 4 and 8 (1) of the
license and section 9 bracket small 1 and bracket small 2 of the Essential Commodities Act 1955. The petitioner thereupon prepared an appeal before the Commissioner, Central Assam Division, Nagaon, which was registered and numbered as case number GG bracket CAD dot 1/2018. The said appeal was allowed by the Commissioner, Central Assam Division, Nagaon, by an order dated 11/12/2019. It is the case of the petitioner that in pursuance to the order dated 11/12/2019, the respondents have not restored the license. And it is under such circumstances the petitioner approached this court by filing the present petition. The record revealed Ms. Yuda, the learned counsel appearing on behalf of the respondent number 125, have placed before this court an instruction dated 11/2/2026, which is kept on record and marked with the letter X. From a perusal of the said instruction, along with the enclosed order dated 3/12/2021, issued by the Additional Deputy Commissioner Nagaon, it appears that in pursuance to the order dated 11/12/2019 issued by the Commissioner, Central Assam Division, Nagaon, the license of the petitioner was restored. However, the said restoration was subject to tagging of about 50 ration cards from the existing fair price shop agent Paradin Ahmed under Dokinpat SS. It is also mentioned in the said instruction dated 11/2/2026 that the petitioner had only 13 beneficiaries attached to 13 beneficiaries. And in view of the policy decision of the government of Assam to tag at least 50 ration card holders to each fair price shop, the petitioner have not been issued the EPOS machine. Taking into account the above, it is the opinion of the court that as the petitioners, as the order dated 11/12/2019 have all issued by the Commissioner, Central Assam Division, Nagaon, have already been given effective by restoring the petitioner's license by an order dated 3/12/2021. Nothing further remains in the instant petition. It is also the opinion of the court that as the policy decision of the government of Assam of taking 50 ration cards against each FP shop have been already upheld by this court in various decisions. There cannot be, this court cannot issue a direction upon the respondents to grant the, to issue the EPOS machine to the petitioner, as the petitioner admittedly has less than 50 ration cards tagged to his shop. Accordingly, the recognition statutes.
But this petition was filed for not payment of contractual agreement.
What is this?
Payment of contractual agreement. But we have received instruction below that a part payment was made However, the amount of security deposit earnest must be PMD and the interest amount will be known.
No interest, what interest? You move the competent civil court, then you get interest, not here. Verify and pay,
30 deposit.
whatever it is, security deposit, where have you mentioned?
But the security deposit load will find. On page number 24.
20 lakhs, 11,946. Isn't it? The total amount,
Total amount was 20 lakhs and all, 20 lakhs 12,000.
what is it you are going to get?
Well, that instructions we have that we got, well, the 2,91,813, that is the security deposit which we have paid, but that has been withheld, the PMD has been withheld.
So you have bought certain amount in
We
the,
have gotten certain amount,
How
the
much?
exact figure I don't have. The morning I got, well, the exact figure I don't have.
no instruction. 2022 matter, you have no instructions.
Preparing on behalf of A dash minor and so they are
Huh? Who is ADAS?
some personal decision.
You are not the counsel for the National Health Mission.
Yes, my lord, I have communicated today, my lord, and because of sitting of the office, my lord, they are not able to give any instruction today, my lord.
Tomorrow? So and so appearing on behalf of the respondents, respondent National Health Mission submits that she will obtain the instruction within 7 days. And takes as to what amount the petitioner is entitled to. To list this matter again on 4th of May 2026. For placing the necessary instructions. Mr. A. Batra, the legal counsel, appearing on behalf of the petitioner, submits that pursuant to filing of the instant writ petition, the petitioner have received certain amounts and only the security deposit in the EMD have not been released. So such instructions be also placed by way of an additional affidavit. This matter again on 4 May 2026. Additional affidavit be filed on or before 7th of 30th of April 2026.
The engaged counsel M. More will come to court to support the
What?
Mr. M. More, the counsel for the petitioner, he could not come for calling out.
Yes, what is it? Can it be filed?
Yes, affidavit file, they file a reply. We file reply. We file reply to.
They file reply.
No, no, we file. Because they filed some bills of 2014 and 15. They filed some bills of 2014 and 15. So we also have to place up some bills of that year and file in our reply.
How much is the total?
2 crores 3 lakhs.
You got a 30 lakhs, 27,000.
And you have paid only 25 lakhs.
That was a condition.
That is good.
Only 84 lakhs was the
25%.
84 lakhs was the principal amount. 84 lakhs was the principal amount.
And
And the rest is surcharge.
can you think
Short accommodation may be given. Mr. M. Moore is not available. Maybe what I know. Mr. M. Moore.
yeah, can be for 5 months back? Why won't you file it back?
Instruction, one of the directors is at Delhi due to his son's operation. 2 weeks time may be granted now.
Oh, you can make it. No, you can what?
The conditional entry.
Huh?
Conditional entry must be.
No, there was no interim order extended after 2024. The interim order has not been extended. Isn't it?
The conditional entry. Conditional entry was there. Then we have to pay.
Understood. See, 18/8/2022 interim order passed earlier to continue till the next date of listing. Matter came up before this court on 20/10/2024 after 2 years. I said list after 4 weeks. The matter again came up on 29th after 2 years again. 29/1/2026, considering that the matter is pending since the year to the last opportunity granted to file such affidavit. So affidavit filed. No interim order has been extended.
A chance. 2 weeks time may be granted to file reply.
The counsel appearing on behalf of the petitioner submits that 2 weeks' time may be granted for filing the affidavit in reply. Taking into account that is no interim order. This court grants 2 weeks' time to the petitioner to file affidavit in reply. List this matter again on 1st of June 2026. In the meantime, affidavit in reply be filed on or before 25th of May 2026.
With your lordship, I am instructed by the corporation to go for amicable settlement, lordship. Because there are some documents which are not provided by the petitioner. Therefore, lordship as per the current status, I will
You are
check.
paying for whom?
I am for the respondent number 1 to 5 for BCR Corporation, Bongaigaon is fine.
Okay. You do one thing. Whatever is he claiming, verify and pay.
Yes,
Verify and find out if he is
Yes, but-
entitled to then pay.
Yes, sir.
Just put verify and pay 6 months. and appears on behalf of the petitioner on call. And appears on behalf of the petitioner as well as the respondents on call. Why no appeal counsel? Accordingly, list the matter of the 2 weeks. Yes,
Stand it for sign, my lord. You will file by this week. My lord.
you are appealing for,
PWD,
appealing for PWD.
my lord. 1 week time, within this.
Pay as per Kamsel. And pay as per Kamsel.
Hello?
Pay as per Kamsel.
Bank guarantee is also there, madam. My bank guarantee is also there. Bank guarantee.
What do I do with the bank guarantee? Have they invoked the bank guarantee?
That's what my prayer, madam. SD money and as well as contract will be and release of my bank guarantee.
The release of your bank guarantee would as per the line. Bank guarantee has become useless now.
Madam, 1 week may legal, my lord. We will file our evidence within this week.
Where is the bank guarantee?
Madam,
Bank guarantee?
Bank.
Where is the bank guarantee?
page 23.
Eight,
23.
20? Where is the bank guarantee? Huh?
This is the bank guarantee.
No, it can't be the bank guarantee. It's an agreement. Where is the bank guarantee?
Reflected 21 lakhs equivalent as bank guarantee.
Understood. That is only, what is a bank guarantee? A bank guarantee is that for a particular period of time, if something happens, they are going to wait. Now, if the period is over, and I don't think the bank guarantee has been there for last 14 years, it has already lost its force. Then
Yes.
nothing. Council. And so along with the copy of the bank guarantee, we also return if the petitioner is there no dues payable by the petitioner. Good, madam. That's the contract. What is this matter about?
Signed a contract work, madam. While I was executing the contract work, an order was filed, the PI by Meghalaya High Court that what happened is the restriction was that more than 10 MP that trucks cannot be allowed to pass. So thereafter, what happened, madam, the shortest distance which was calculated as 120 kilometers, that would not be operating, the operation of law, madam. So then notification came, then I was required to transport the thing to another route, which was around 180 kilometers, 50% high. So my claim is that, my lord, regarding that, my lord, I am entitled for judgment rejected by SBI.
Go with the civil court. How do I know?
Not without situation that order has been passed.
By one of the coordinate bench, my lord, one of the coordinate bench in the similar situated matter, the matter has been referred to the civil court, to the petitioner.
Because you see, these are various things. How much you have taken, all these things are there.
Now, only regarding the date, my lord, the date which we are getting, disputed question of fact in my submission is this, my lord.
It is not a question of disputed questions of fact. It is a question of These are various things which needs to be looked into. How much you have how much you have done it. Whether you are entitled to, whether it is 180 kilometers. These are questions.
No, that is a matter of record. The distance and everything, while giving the work to me, my lord, a committee was constituted. And the committee has personally kindly come to my lord, state. They kindly come to my lord. They are reply, my lord. They have filed. There a report has been enclosed, my lord, page 89, my lord. They kindly speak for a one.
What are the impugn orders?
In order is the order, I have to file an application to PRC, my lord, the in-house system. Another contract act, and page 65 is the order, my lord. They say that I'm not entitled.
Let's see the NIT.
That is page 25.
8.
25. 26 is relevant, madam. The contract for 2 years and 23. Serial number 4 is my work.
Then
Can be one, my lord. They are doing, my lord, no request for increase.
let us, huh?
Madam, that, page 26. The below the schedule, my lord, there is one thing like NB1. No request for increase in quoted finish power and temperature on the diversion change in the route from point to point. But here, my lord, my case is that operational flaw came into my lord, the picture, my lord. Into the order passed by PI, my lord. Cosmically, see, my lord, for a moment, my lord, page 89, my lord. Document will be relevant. My lord. 89, my lord, before giving me the work, a committee was constituted to see the distance, my lord. And Lakshmi kindly see at Chamsari to Shillong at A, my lord. Distance is 118.2. This is the shortest distance. It is via Umiam Bridge, that Borapani Bridge. And next page, Lakshmi kindly see they have also calculated the another distance that is through Mount Ringhan. That is 190. So once the that was closed, my lord, for me, my lord, I had to operate it.
Then
So
where is your contract awarded?
record of appointment is 29 and appointment is 31.
So when the contract was awarded to you, where is?
Letter of appointment is 29, my lord.
Huh?
Letter of appointment, my lord.
29.
Accept this, my lord. Accept it. Letter of acceptance.
Hmm?
Letter of acceptance, my lord, my quote was 1095. It was quoted in consideration of the committee report that the shortest distance will be 120 kilometers. As appointed by order dated, but next page, my lord.
admittedly, the rate was for the entire distance fund. That is there, also. That is there. For my case, in that matter, here, a situation like force majeure came into place due to which matter, by operation of law, I could not operate the shortest distance as per their requirement. So I had required to make the 10 kilo, 10 MT is the load of the truck itself. In the contract matter, NIT, it was mentioned that already there has been ordered by in the PIL that 20 MT I have to maintain. Knowing that 20 MT is the limit, I joined there. But when I was operating this 20 was brought down to 10 matter. That is the shortest distance became inoperable matter. Then I had to operate that 180.
So show me a provision of law how you will be entitled to for more.
Under the contract matter is not there. Under the contract it is not there. Because it is point to point. Their case also matter. But this is a case matter of the kind. It is not that I claim diversion for some other reason and all.
So it's a, isn't it just purely a contractual dispute?
If let us see contracting. There's an agreement to do an act impossible in itself is why. Contract to do an act afterwards become impossible or unlawful. The contract to do an act which after the contract is made becomes impossible or by reason of some event which the promisor could not prevent, unlawful becomes void when the act becomes impossible or unlawful. Here it is not slightly different manner. It's not exactly fitting that totally
So
inoperable.
show me a provision in the contract act where you can get movement.
Section 70 law should kindly see quantum merit matter. Person enjoys benefit of not getting the friend. When the person lawfully does anything for another person or delivers anything, he not intending to do so getting the such other person enjoys the benefit thereof. Later is bound to make compensation the former respect of to restore the thing. So can't forget. Also documenting post mature clause. That also takes care of my case, post mature. Context, well, can see there and each what take. Eight. They are also.
800.
They were trying to be able to simple. The page 105, clause X 195. The contractor will not be responsible for delays may arise on account of reasons beyond their control, of which the general manager sets the final judge. Rights by contractors to workers on account of the contractor will not be a reason beyond the contract. So this is excluded contract and all manner. Exactly, my lord, does not fit anywhere, my lord. I submit, my lord, but you lordship, would sit together, my lord. Here is a case, my lord, where the legal ban came out. And the distance, both the distance were in record by the committee. One is 120, one is 180.
So shortage distance was given, I came to know about it, I quoted my bill. And knowing that there was already an restriction imposed by the High Court, that 20 MT is the restriction. But 10 MT is the truck and 10 MT I can. Then came the 10 MT, therefore my lord, we granted absolutely possible to.
Your case reminds me of a case. They- it's a book. That's a book which is said to be a details on contracts. What happened? There was a shipment which was to go through the Suez Canal to Europe. The Suez Canal was blocked because of the problem that happened on account of Egypt or something. So there's some problem with them. So this particular shipment had to go down from Cape of Good Hope, down below, and then go towards and to the port of Gibraltar. It went to Mount became very high. So the question arose out there whether, because this 56 is similar to also drawn from the Anson's Book of Contracts. So the question arose whether it is impossible. So it's not impossible. So the benefit was not given. But however, in 1954, one judgment came of the Supreme Court, wherein the Supreme Court said impossibility which is given out there by the as per the English law is different from impossibility as per 56. But that is a case where the contract would be void. If the contract is void, mean you need not perform. So there cannot be. But here you are on one hand trying to place 56 or the force majeure. And on the other hand, you are trying to get benefit out of the same contract. How is it possible? You may have said, okay, I'm not going to do it. And still look out, they may give it or may not give. But you on your own, put into and read the distance. It is placed in a representation to
Yeah, not for representation, only for enhancement of.
no, at that point of time, prior to going ahead,
Yeah,
that we cannot now go by dates. And we have to, this way, there will be more. What to do? Did they allow you?
no, but I was continuing with the thing because if I don't continue, the penal thing will follow my lord.
Then that is why you get the benefit on the 56. So these are best cases scenarios who want to marry, which I also find very difficult. The read to exercise. Better not things go to the full form.
I understand, madam. State jacket may not, it does not fit to any provision, madam. But here's the problem, which is absolutely legal problem and admitted thing that it happened, madam. It's not that.
No, because there will be many cases. You may have to prove that before taking it, I have taken the concurrence. They have accepted it. These are things which you have to prove it. That they have accepted the goods, that they knew about this. Because you see, the Contract Act 56(3), there's a very interesting aspect. 6. Second paragraph. Compensation for the loss through non-performance of act known to impossible of being. Where one person has promised to do something which he knew or was reasonable provisions might have known, and which the promisee did not know to be impossible or unlawful. Such promisor must pay compensation to such promisee for the loss which such promisee sustains due to non-performance. But this is on which you have to proceed before the Supreme Court.
I want to add another thing, my lord. The petitioner was well aware of the restriction imposed by the government of Meghalaya before the NIT was issued, my lord. Here the NIT was issued on 11/6/2021, whereas there was a press release by the government of Meghalaya giving the restriction, my lord. Page number 125, my lord, can be seen. So petitioner, before bidding for this contract, he was well aware that there was a restriction of 20 MT, my lord.
Well, very much clear.
And after this, he has applied.
As the FCA given you so many briefs, you don't want to fight it out in the civil court and make the.
I'm just, that's why I have said stated that I want to add another thing.
The moment I take that.
Yes, ma'am. Yes, ma'am.
He wants to go to the civil court.
I would have been happy, my lord, little bit like it here, my lord, but what I understand, my lord. Even if they consider something at all. The Swiss color judgment has been, that part has been recorded in the Supreme Court judgment, 2017, 14 has been, my lord. You will also refer to the Swiss color. That has been referred to 2017, 14.
No, in fact, thereafter, that is the oldest. That is the
Old, very old.
That's a House of Lords.
Yes, sir. That has been quoted there.
Yes, but thereafter, you have a 1952-53 judgment. This is Subara.
Satyavata.
I think so.
Satyavata court, but
There, the Supreme Court say the impossibility which is considered out there by the House of England in England is different from what happened. So therefore, is a thing which is not necessary that it should become impossible. Possible means it's not possible.
not possible at all.
Not possible. So that is how, what was the interpretation by the English? But Supreme Court, it's a five-judge bench. Said that no, it won't be. If it becomes impossible means by on the basis of a reasonable person's perspective, it cannot. These are to be argued when I'm taking up civil bench one. Heard Mr. So the learned counsel appearing on behalf of the petitioner and Mr. So who appears on behalf of the FCI. The petitioner herein is agreed by the order dated 29/2022 issued by the Grievance Redressal Committee.
Director, based on the GRC report.
Is agreed by the report of the GRC of the Grievance Redressal Committee dated 1/9/2022. Thereby rejecting the petitioner's appeal and the consequential order dated 29/2022 passed by the respondent number 3. The brief facts which led to the filing of the instant writ petition are that the petitioner herein is the contractor engaged in the business of transportation. Works under the Food Corporation of India. A notice inviting tender was issued. Notice inviting e-tender was issued on 11/6/2021 for from eligible contractors pertaining to handling and transport contract as well as for road transport contract. The petitioner being interested participated in the said notice inviting e-tender for the road transport contract for the work that is Road Transport Contract Act FCI siding Sangsari bracket CFCC to FSD Shillong via Weybridge. It is very pertinent to take note of that in the said notice inviting tender, and more particularly e-tender, and more particularly the note being NB1, it was stipulated that there shall be no request for increase in quoted rate bracket S per MT on the plea of diversion of the change in the route from point to point on any account. The petitioner being successful in submitting its bid was issued a letter of acceptance on 29/9/2021 at the rate of rupees 1095 per metric ton for the entire distance. Ex FCI siding Sangsari bracket CFCC to FSD Shillong via Weybridge on regular basis for period of 2 years. It is the case of the petitioner that on 4/5/2022, the High Court of Meghalaya had directed the closure of the Umiam Breach. Anti-restriction. The closure of the Umiam Breach to all vehicles beyond in excess of 10 metric tons. The resultant effect of the said order passed by the learned Meghalaya High Court was issuance of an order on 11/5/2022 by the Superintendent of Police, Vikoi District, thereby stipulating that the maximum permissible limit of Umiam Spill Weybridge, itu agota WAY, should not exceed 10 metric tons. It is the case of the petitioner that the distance for which the petitioner had quoted its rate of rupees 1095. Where is that report? Was taking into consideration that the transportation would be made via the Umiam Bridge, which was
and the distance of which was 118.2 kilometers. However, in view of the intervention, in view of the order passed by the learned Meghalaya High Court and the consequential directions issued by the Superintendent of Police, the petitioner had to take a different route, that is through the Mawrynkeng, Mawrynkeng, and the resultant distance was 190 kilometers. The petitioner, out of fear that penalty would be imposed for not going ahead with the transportation, fulfilled the terms of the contract by proceeding through by carrying out transportation through the longer route of 190 kilometers. The petitioner had to incur additional expenses on account of the distance having enhanced, and as such sought for compensation for compensation on account of the additional distance. This request made by the petitioner was rejected by the Grievance Redressal Committee by its report dated 1/9/2022, and subsequently intimated by the respondent number 3 by an order dated 29/2022. It is under such circumstances the petitioner is before this court. The respondents, pursuant to the notice by this court, had filed an affidavit in opposition thereby supporting the report of the GIC, as well as the impugned order issued by the respondent number 3. It is the specific contention of the respondents in the affidavit that the notice inviting tender, the terms and conditions of the notice inviting tender were absolutely clear. That there would be no escalation on account of diversion would be entertained. In addition to that, the respondents have also mentioned in their affidavit in opposition that the rejection of the petitioner's claim for additional compensation was done so as per the contractual terms and conditions. And there was no illegality or arbitrariness for the invocation of the public law remedy under Article 2 to 6 of the Constitution. It was also mentioned at paragraph number 18 of the said affidavit in opposition that the government of Meghalaya Transport Department had issued a press release dated 30/4/2021 pertaining to goods laden vehicles flying over the Umiam concrete bridge directly to directing to strict maintenance of the gross weight of any goods laden vehicle flying over the Umiam bridge up to 20 metric ton, bracket one vehicle at a time. It was further mentioned that the matter on restrictions on the vehicle flying over the Umiam bridge by the government of Meghalaya was in news since long, which was evident from the notification of the press releases issued from time to time by the government of Meghalaya. It was also mentioned that a notice inviting tender was issued on 11/6/2021, and the aforesaid fact existed was known to the bidders, including the present petitioner. The petitioner had also filed an affidavit in reply stating in alia that the notifications which have been referred to at paragraph number, the notices which have been referred to at paragraph number 18 of the affidavit in opposition permitted vehicles with 20 metric tons to ply. However, on account of the orders passed by the learned Meghalaya High Court, only vehicles less than 10 metric tons were allowed to ply. And therefore, the fact that the petitioner was aware prior to submission of the bid in pursuance to the notice inviting tender dated 11/6/2021 was a misconceived statement made in the affidavit in opposition. The petitioner further stated that the respondent authorities, being a state within the meaning of Article 12 of the Constitution, has to act fairly, reasonably, and rationally. And therefore, cannot be permitted to deny the petitioner the additional amount which the petitioner had to incur on account of the extra distance. This court have duly heard the learned counsels appearing on behalf of the parties and have also whose submissions were aligning with the pleadings, and as such, for the sake of brevity, this court is not reiterating the same. Remaining, let us do it after lunch.
My lord, I beg to mention item number 42, my lord. I have been newly engaged in this matter, and my learned senior from the FCI has intimated me that they have not received a copy of the petition. If my lord may permit, I'll provide with a copy of the petition. Matter can be taken up some other time, my lord. Item number 42. Take it as the last item of the day. Wait till much. Otherwise, we'll dismiss for default. I'll wait. Don't mention at the time when it is not. This court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration. The materials and records show that the notice inviting e-tender dated 11/6/2021, more particularly in respect to road transport contract, had categorically stated the following at NB1, which is reproduced during under page 26 of the state. It is further pertinent to take note of that a contract in question was not awarded on the basis of distance, but rather awarded on the basis of the quoted rate per MT. At that relevant point of time, when the petitioner received the letter of acceptance, that is on 29/9/2021. The order dated directions which were passed by the learned Meghalaya High Court, thereby limiting the vehicles bearing a total weight in excess of 10 metric tons was not in operation. The consequential order which was passed by the Superintendent of Police, Riboy District, dated 11/5/2022, is also subsequent to the submission of the bid by the petitioner, as well as the letter of acceptance which was issued to the petition.
petitioner hearing claims that the petitioner had quoted the rate taking into account the distance from X CFCC bracket FSD Sangsari to FSD Shillong via the Umiam Breach, which is 118.2 kilometers. But on account of the order passed by the learned Meghalaya High Court dated 4/5/2022, as well as the order issued by the Superintendent of Police, Reboy District dated 11/5/2022, the petitioner claims that the petitioner had to travel an additional distance, and that additional distance through Mawkeng Mawryngen, which is 190 kilometers. Be that as it may, it is very pertinent to take note of that this court is exercising the jurisdiction under Article 2 to 6 of the Constitution, not as an appellate authority, but only to ascertain as to whether the actions on the part of the respondent authority are unfair, unjustified, and arbitrary, or contrary to the settled terms and conditions between the petitioner and the respondent corporation. This court have also perused the report of the GIS or the GRC, wherein applying the contractual, applying the terms of the notice invite e-tender and the modern terms and conditions of the contract, have rejected the petitioner's claim. The learned counsel appearing on behalf of the petitioner submitted that the petitioner is entitled to additional compensation on account of, on the basis of the principles of quantum merit as enshrined in Section 70 of the Indian Contract Act, 1872. If that be so, the petitioner has to place relevant evidence in that regard as to whether the petitioner is entitled to the quantum merit on the basis of the principles of quantum merit. More so when this would require adjudication of factual disputes pertaining to as to whether the petitioner have taken certain permissions prior to initiating prior to diverting the transportation route on account of the closure of the Union Bridge. On the basis of the reports so submitted by the GRC, appears to be in terms with the contractual terms and conditions. And as such, the same cannot be said to be unfair or arbitrary. For exercising the jurisdiction under Article 2 to 6 of the Constitution, the said opinion, however, is in the context of exercising the jurisdiction under Article 2 to 6 of the Constitution, and not an adjudication as to whether the petitioner is entitled to additional compensation on account of the principles of quantum merit as enshrined in Section 70 of the Contract Act, Indian Contract Act 1872. Considering the above, it is the opinion of this court that this is not a fit case for exercise of jurisdiction under Article 2 to 6 of the Constitution. Accordingly, the writ petition stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not preclude the petitioner to claim additional compensation if you are entitled to in the law from the respondents. And the observations so made herein above shall not prejudice or preclude the petitioner to file a suit before the competent court of civil jurisdiction, basing its claim on the principles of quantum merit. But the period from this would have also taken note of that the petitioner have been diligently and bona fide pursuing its remedy before this court on the assumption that this court would have the jurisdiction. As this court is not inclined to exercise the jurisdiction, its extraordinary jurisdiction in the present matter, it is the opinion of this court that the petitioner would be entitled to the benefits under Section 14 of the Limitation Act 1963 for the period during which the instant writ petition has been pending, that is, from the date of filing till
Right.
Lordship, in compliance with your lordship's order dated 9th of December, we have deposited the amount, and that has been also reflected in being and flag marked as deposit note.
what amount?
8 lakhs, 8,82,533.
You've taken the money. What do you mean? You don't have a case.
Second part, you know, let's further examine that part regarding the benefit from 24, 25, 2018. What I have stated, my lord, that till date they have not served me any replacement of the effort of section 25 F of the law. If they can show that they have fenced me as per the section 25 F of the law.
Who is the petitioner? You are challenging the order
Yes, Your Honor.
on the ground of 10 times.
On the ground of 10 times, as well as they claim that the retrenchment has not been served. It is an admitted position is given in their petition as well, Your Honor. In page number 36 of the petition, which is their application before the principal secretary. Paragraph number 4. Page 36. May I read it? That, sir, to the utter surprise and dismay of the petitioner, the ITC Limited Company is indulging in misleading deeds. Instead of paying the error wages to the petitioner, as per the terms of the conciliation proceedings, the ITC Ruby has sent a letter to the petitioner dated so and so under the caption order of retrenchment dated so and so, along with the demand draft amounting to 2,23,627. So retrenchment order was sent, he has refused to take it.
Which page? Page?
36.
Huh? You are referring to which page?
Page number 36 of item number 30.
4965.
Yes, sir.
In page 36, where are you mentioning?
The last paragraph, paragraph number 4.
Considering all the facts, I direct you to pay so and so. In 7 days from the date of receipt
Your
of the
Honor,
order.
39.
Insert with the other dismay, supplies and dismay, paragraph,
Paragraph 4, the last one
which one?
of the page. That's sir to the utter surprise and dismay of the
Paragraph.
Oh,
What do you mean? Now, my lord, your lordship has correctly about this order. Lordship has interpreted with that provision regarding 10 times. Now, my lord, the issue which was decided was between the period 1/1/2016 and 1/5/2020. Now, my lord, on the last occasion when this order was, when this matter was heard, my lord, your lordship said that regarding the remaining part, whether retrenchment was actually done or not, that we will hear it. How can I decide? Because they have to show, my lord, that they have issued the retrenchment order as per section 25A. If they have, they can show before this honorable court that they have. Why should I look into that? Because that aspect now you will, because the period which they. He has filed the petition challenging the order dated 15/7/2022. Isn't it? Wherein they directed payment of 82 lakhs. Okay? You have challenged, you have come before the court for non-compliance to the order dated 15/7. Okay? In my last order, I have made it very category that the imposition could not have been for 10 times. The amount which you could have been entitled 8,32,000. And accordingly directed them to pay the. I kept the matter only pending for the purpose that if they don't pay, then I can catch you. The question is to whether retrenchment has effect or not. It's a question which you need to ask for further views. Go there. Why should I? I'm not going to give a direction in this. You go there. That direction can be given to me. That direction can be given to me. Why should I give you a direction? You are at liberty. You got that amount. Why should I entertain a dispute as to whether there has been retrenchment or not? You claim an amount that for further dues. Let them come up and say that we have already retrenched. That is an adjudication that authority will do. And after that, obviously, we are here to look into. That part, I mentioned there, that part already will be taken care of by the optional labor, by the existing labor. What? They have themselves stated that we are withdrawing the that investment part. They're saying that we have differentiating so well. No, could be wait. Why should I adjudicate? This case that you have retrenched, it's there. Where? There. No, what is the finding they asked? They didn't ask for that. They're refusing what is there. As to why years pending before the year should not be set aside. They are only challenging the 15/7 order. The fair part final stated that I am not entitled to anything because I follow in terms of your outside. Wait, let's see. Page 22. Where? Five of them. Where? However, once see it's next pair of 6. That's why I refused to join so the services become redundant. Other completing circumstances, but no other option but to return to the responded number of this temporary employment. Did from 1 month. How many is taken care of in that consideration? So lordship also reflected. However, thereafter, when I filed an application
on the year 2021 regarding non-compliance with the conciliation proceeding. There also they again came up with the same, when we have subsequently replaced in the year 2020, which he has reduced the exam. That was also taken care of in the subsequent order at in that page is it stated that no, this was not. That is why that period final, so your lordship also take the order, the period from
You are Mr.
2016 came.
You seen my order, that order which I passed. What is the direction?
Regarding that, issue whether that,
What is the direction I gave?
to deposit that amount of reflection.
That amount is for which fee?
That amount is for the period, my lord, 1/1/2016, 31/5/2020. So, my lord, what is my case, my lord, I have also. It is
So
my-
why should I? Where is your petition out here you are asking for?
So, my lord,
That you are not retrenched. Why should I give a declaration?
My lord, I agree with the lordship.
Then?
Your lordship will, that is why my lord, I'm-
You should be,
Observation.
you should be happy.
It's, yes, your lordship,
I have interfered with the 15/7 to the extent that he could not have imposed 10%, 10 times. Whatever the salary, that is the finding of fact by the authority. I am not touched from that. But the salary which is there for disputed is this, and additionally for non-payment of the salary, the imposition would have been where at best is 3,000. It could not have been multiplied by 10 times. So I interfered with that order and leave directing them to pay it. I kept the matter only pending, because if I am not pending,
for an update whether they have paid or.
you may have a good thing for the purpose of you may file another, you have to file a contempt case.
Yes, sir.
You need not file a contempt case if I keep the matter pending.
Yes.
That is the reason why I kept the matter pending, so that they make the payment. Otherwise, a direct, then they won't pay, then you have to. Now you are a person who have been retrenched or not retrenched or whatever, maybe you have no salary.
Yes.
Now the salary you are not there, so for you to again come before this court and take a particular amount and file again another thing, for that benefit I keep the matter pending. Otherwise, I have already interfered with 15/7. Your case is 15/7 should be implemented. These cases, 15/7 cannot be implemented, taking into account that 15/7 multiplied with by 10%, by 10 times. I interfered with 15/7 saying that the amount which is entitled to 8,42 of direct debit. I'm not said also this amount is also subject to outcome. Given liberty to release the NIA and disburse it to the bank account, not even indemnity. Although Madam Hazarika on that day sought for that, I said no, nothing. So therefore, you should now say, I have received the money. He said he has paid. Use. Now you know, got the payment for which time?
From the period 2016 to 2020.
Now you are a very clever lawyer, as I know. You are. So what is to be done?
No, my lord, yes, is absolutely correct, your lordship.
What is to be done? Should you further say that this court should look into that? The moment this court looks into that, you are asking me to review my order, which may affect you, which he wants. You want him, you are trying to help him.
Your lordship order is absolutely correct. I'm just seeking a correction that regarding.
What he has said. You have the CPC with you?
And I can get.
Yeah, I give him a the CPC.
You know, 86 September, constructive certificate apply, need explanation fine. So could I make you more clever? He says yes before the. I will look at receipt it. Have fun. You know what to do. Right? Because he has not come before this court saying that kindly hold that he is not a witness. He has not come before this court. He has come on the basis of challenging 57 on 10 times. I'm interpreting. Art Mr. K. Mohammed, the learned counsel appearing on behalf of the petitioner in WPC number 4965 of 2000. And Mr. Nikhan, the learned counsel who appears on behalf of the petitioner in WPC number 5390 of 2000. Because if it is a case of retrenchment, it would be an industry dispute. Then you move an application under 2A. Capital industry dispute. And fight it out. This vote, by then, Mr. K. Gogo appears on behalf of the, you appear for a senior government, additional senior government advocate appears on behalf of the state of Assam. This court had passed a detailed order on 9/12/2025, whereby the primary issue which was before this court in both the petitions have been adequately dealt with. For the sake of clarification, for the sake of clarity, this court would like to repeat that the issue involved in the WPC number 4965 of 2023 was relating to the non-compliance to the directions passed by the additional Labor Commission. Assistant Labor Commission in its order dated 15/7/2022. On the other hand, it was the case of the petition in WPC number 5398 of 2023 that the orders were passed by the Assistant Labor Commissioner, including order passed by the Assistant Labor Commissioner dated 15/7/2022, was without authority and jurisdiction. The observations so made passed by this court in respect to the order dated 15/7/2022 passed by the Assistant Labor Commission in the order passed on 9/12/2025, and more particularly the paragraphs number 13 to 19 being relevant are reproduced hereunder. A perusal of the above quoted paragraphs clearly show that this court held that the impugned order dated 15/7/2022 passed by the Assistant Labor Commission was without jurisdiction insofar as imposition of penalty to the tune of penalty. Right, for the imposition of penalty in terms with section 15(3) of the Act of 1936 of the Payment of Wages Act 1936. And it was the opinion of the court that the Assistant Labor Commissioner, by passing the impugned order dated 15/7/2022, had wrongly applied the provisions of section 15 of the Act of 1936 in the proper perspective. It is under such circumstances, this court directed the petitioner in WPC number 5398 of the 2023 to deposit the amount of rupees 8,32,533, thereby modifying the impugned order dated 15/7/2022. And it has been brought to the notice of this court that the petitioner in WPC number 5388 have duly deposited the said amount before the registry of this court, and the petitioner in WPC number 53434965 2023 have also received the said amount. Considering the said observations, it is therefore the opinion of the court that nothing further remains to be adjudicated in the instant with petition. And accordingly, both the petition stands closed with an observation that in view of the order passed by the president, in view of the instant order and the order dated 9/12/2025, the impugned order dated 15/7/2022 passed by the Assistant Labor Commission stands modified in terms with the order dated 9/12/2025 passed by the school. One thing, Mr. Mohammed, the sad part is I couldn't allow you to file a contempt. That is the lawsuit. Yes, what is this? Kedarnath Pathak. What is this matter? What? Mobile? What do you want? Issue a direction to further inquiry on the documents so please relied by remand and also verify the other requirement for obtaining license to install. Who are you? I'm the petitioner. There I know. Who are you? The mobile tower. It's nearby your house. What is wrong with it? On earlier occasion, the petitioners approached this court, and this court directed the deputy commissioner to follow some instructions, take into the grievances of the petitioner. The page number is 76, the regular question of the order. Page 72. Of the order of paragraph number 6 and 7. Page 70. Except G.
Then what happened?
No speaking order was passed. But now anything is not any skill operate.
Where is the necessity of passing a speaking order? Where is the necessity of passing a speaking order? Let us read it together. Where did I don't see that's the word speaking anywhere. Here it says it is accordingly directed. After due consideration, the DTC shall dispose of the same by passing a speaking order. Now the DTC has not passed a speaking order.
DTC has not passed a speaking order.
Who is the DTC?
We have filed an RTA application.
Who is the DTC?
DTC is represented by the deputy commissioner.
How do you know?
It is reflected to the.
Yes, Deputy Commissioner, why haven't you passed the order?
Some meeting is also there, also that page 70, 77, Lordship. Their application has been rejected, Lordship.
Huh?
Their application has been rejected, Lordship. Annexed case, page 77. Last paragraph.
English you have written. Where is the
Earlier round of litigation Lordship, that the judgment Lordship, your Lordship come page 71, paragraph 4 and 5. If they are not satisfied with the decision of the DTC, then they have the right to prepare an appeal before the State Telecom Committee.
yeah. 19B. Page 95. How's this telecom covering? So you see, it's the way that you the respond to the court. Eastern Director General Compliance, Assam, it's Who is paying for the Department of Telecom? You have made them a party, no? Have to get hold of the Union of India. No Union of India comes with that. Yes. You see, this affidavit which has been filed by the respondent number 4, Director of Compliance Department of Telecom. They have filed an affidavit. They have enclosed that you are now being duly taking note of this pursuant to an order passed by the Allahabad High Court. You have a office memorandum dated 27 to 2015. Now here it says, in order to get the latest updates on EMF radiation related issue, DOT will actively participate in the deliberation of various international standard bodies, including groups involved in so and so. Like the so and so shall step up to forward to spread awareness on EMF and above precautions regarding mobile phones to allay undue apprehension in regard to so and so. This can be done so and limits. Have you got it? Page 120. Huh? No, no, page 120. The affidavit file will respond number 4.
It's not for page 122 is not there. 121 is there, 122 is blank page. Then 123.
We don't have, yes, there is a. Some person has filed, some Krishna,
Cap one, probably cap one.
she is not there.
Cap one.
We do one thing. She is not there, we direct this particular person to appear. This is Aduri Naveen. Let her appear.
Yes, no.
Let her appear in the court. My question is whether you are complying with this office memorandum or not.
Not every day.
Huh?
And not every day part of it, because
Then the council is also not represented.
Tuesday, tomorrow, day after tomorrow. No.
And Mr. Esabulwa, your manner in which you have disposed of this order, it's not how you do it. You've just done it for the sake of. Kindly explain me what is it. Where is the document? Where is the order, impugn order?
Page 77.
Yes. Kindly explain to me what do you mean by the last two paragraphs, taking part in the discussion. Please explain to me. Very difficult to understand. You explain. Taking part in the discussion, so-and-so manager, Reliance Geocom stated that most of the mobile tower installation process have been stopped owing to radiation issues. EMF radiation level could only be checked after the tower starts radiating. Hence, permission for continuing the installation process may be given. So, you are going to proceed. On the basis of the above, it is decided that the application submitted by so-and-so is rejected. How? That too after an order passed by the High Court. and you want him to go and file an appeal. And the court fact remains that is the mobile tower now operational? Then they will check it.
It's creating from 12. Creating from 12.
20? Do one thing. Day after tomorrow, give us the radiation level. Take it. This is not how you do it. This is absolutely. What is wrong with this deputy commissioner? Was he busy with his elections? Huh? Goodness. No, it is categorically same. No, he could not have rejected it. He is alleging that radiation is the problem and therefore don't have it. So therefore the court says, okay, go and let the DTC look into it. DTC says, okay, these people are going to install it. Once the installation will be done, they will check it. But you rejected it. Check it out as to whether it is in compliance with this. Therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. First of all, Mr. S.R. Bulwa appears on behalf of the respondent number 5, 9, 10. First of all, Mr. King Owe appears on behalf of the respondent numbers 2, 3, and 4. If you go to 5, 8, 8, 8, 9, 10. King Owe appears on behalf of the respondent numbers 1. You appear for 1 also, no? 1 and 8 also. Appear for 2, 3, 4. None have appeared on behalf of the other respondents on call. You are appearing for? When so appears for the PWD. None have appeared on behalf of the other respondents on call. This is the second round of litigation. Filed by the petitioner, being agreed by the actions on the part of the respondent authorities, more particularly the Deputy Commissioner Sipsagar, in rejecting the petitioner's application. It is relevant to take note of that in the earlier round of litigation, which is WPC number 3235/2022, the learned coordinate bench of this court by an order dated 13/6/2022 disposed of the said petition with the following observations at paragraph number 7, which is reproduced here in under. From a perusal of the above quoted paragraph, it is seen that there was a direction issued upon the DTC, bracketed District Transport, District Telecom Committee, Chipsagar, to dispose of the representation submitted by the petitioner. After giving an opportunity of hearing to all the stakeholders,
In pursuance thereto, a minutes of the meeting was recorded on 17/12/2022 by the Deputy Commissioner Sipsagar. And the petitioner's representation was rejected without assigning any reason. That too, when this court, by an order dated 13/6/2022, have directed the DTC to dispose of the representation by passing a speaking order. This court have also taken note of the minutes of the meeting dated 17/12/2022. And from a perusal thereof, it is seen that the manager of Reliance Jio Infocom Limited had categorically stated that the radiation level cannot be looked into unless and until the mobile tower is installed. No reasons was assigned, but the Deputy Commissioner rejected the representation with a further direction to the Director of Telecommunication to make an arrangement for verification of radiation level of the mobile towers installed in Sipsagar district. This court have also taken note of the affidavit in opposition filed by the respondent number 4, wherein it is mentioned that the government, that in pursuance to certain directions passed by the learned Allahabad High Court, Lucknow Bench, an office memorandum dated 27/2014 have been issued by the Ministry of Communications and IT, Department of Telecommunications, Government of India, wherein the limits of levels for antenna bracket base station bracket close EMF emissions for general public exposure have been categorically mentioned. This court fixes this matter again on 22nd of May 2026. In the meantime, the respondent number 4 is directed to carry out necessary verification as regards the emission of the tower, which have been complained of by the petitioners in the present proceedings. Inasmuch as it has been submitted at the bar by the counsel appearing on behalf of the petitioner that the said transmission tower is operational. The District Commissioner, Sipsagar, who is the respondent number 5, is further respondent number 5 and the chairperson of the District Telecom Committee shall also submit a report, submit an affidavit justifying the impugned order, impugned minutes of the meeting dated 17/12/2022 and the apparent non-compliance to the directions passed by this court in the order dated 13/6/2022 and the relevant part of which have been quoted herein above. The said affidavit be filed by the District Commissioner on or before 18th of May. Things will improve.
My lord said director has to obtain inspection and file an affidavit. But also I am not receiving inspection, otherwise also the contextual these documents go to the matter, directing them to the immediate amount of.
Remember,
Lost this one. Railway Katika division. Then yesterday evening also I have communicated to them, what they said that some negotiation is going on between the petitioner and the reviewer. That part they have. Otherwise also the disposal of the matter, I think not that. Admitted amount also. They are entitled to.
you have got some amount.
Final bill, they, as per their. They have, this is a final bill, but the part is not there. Authorized page 26. Page 26. Put it 25 and 25. Platform lawsuit.
Why are you filing it here? NFBB.
That is within the jurisdiction of the agency. That's why they are filed. Otherwise, it is,
So you run a place. Do you move here? This is why the difficulty is not being able to. Where is your final bill?
Extra 6 page 27. That is not a limited amount.
This is not a final bill. You have submitted the final bill on in 2018. And we are today, you approached them by writing a letter in 2020. Yeah. After 5 years, and then you move this court in the year 2023. 21/5/2023, and you move this court on 8/11/2023. Why here? Huh? What's COVID? COVID was long time over. This is for information that the work has been stopped and in working state at so and so dated so, but the final bill of 2018, when COVID was nowhere nearby, even in Wuhan. Then why should we entertain this type of petition? I'm going to entertain this type of petition. After such a long time, we have not written any letter also prior to that. Why? Prior to that, in 2021, we have received a letter. Kindly see page 24. Your final bill is of the year 2018. Okay. This is a letter of 11/10/2021. Okay, page 23. We are still ready to complete the remaining work subject to handing clear and complete clear. Then where is the final bill business? Huh? Go before the civil court in Katia. Type of regulation cannot be. Everything is in Bihar. Urge Mr. So the limit council is giving on behalf of the Commissioner, Mr. K. Gogoi appears on behalf of the respondent. The petitioner herein has approached the court seeking a direction upon the respondents for payment of the final bill amounting to rupees 8,42,284, as well as the earnest money amounting to rupees 3,94,970, along with interest at the rate of 18% per annum. The brief facts which led to the filing of the instant petition are that a tender notice was issued dated 5/7/2018 for performance of work at Katia for provision of washable apron for platform number 4 and 5. The petitioner participated in pursuance to the said tender, and the petitioner's tender was accepted at a total cost of rupees 463,04844.31. A contract in that regard was also entered into by and between the petitioner and the respondents on 6/8/2019, and the period of completion of the work was fixed on or before 13/5/2019. It is the further case of the petitioner that though the contract agreement was entered into on 6/8/2019, But the letter of acceptance was issued on 14/9/2018. And the petitioner mobilized his resources upon receipt of the letter of acceptance. It is the further case of the petitioner that the contract expired on 13/5/2019, and the petitioner made request for granting extension of time to complete the work. But no extension was granted. It is the case of the petitioner that the petitioner had submitted the final bill on 8/4, final bill of an amount of rupees 8,42,284. The said amount, however, have not been paid, and the petitioner's earnest money deposit of rupees 3,94,970 was also not paid. The petitioner thereupon submitted a demand letter dated 21/5/2023. And the same having not been considered, the petitioner approached this court by filing the writ petition on 8/11/2023. This court issued notice on 13/12/2023. No affidavit in opposition, however, has been filed by the respondents in spite of various opportunities. This court duly takes note of the documents which have been enclosed to the writ petition. And it is the specific case of the petitioner, as could be seen from those documents, that the last date, that the date of completion of the work was on 13/5/2019, and the petitioner could not complete the work. And in the year 2021, more particularly on 11/10/2021, the petitioner sought for extension by 15 days for completion of the work. It further surprises this court on a perusal of the representations submitted by the petitioner after 5 years from the date of submission of the final bill of work, that is 29/11/2018, of an amount of rupees 8,42,284. And thereupon submitting a representation in the year 2023, and immediately thereupon approaching this court by filing the present petition. The materials on record which have been placed before this court does not inspire the confidence of this court for granting any relief in the instant proceedings, as the materials which have been placed are bereft of material particulars. Which would prima facie even show that the petitioner has been able to make out a case as regards the claims so made in the instant proceedings. Accordingly, This court, in exercise of the powers under Article 2 to 6 of the Constitution, is not inclined to exercise its extraordinary jurisdiction in the facts and circumstances of the instant case. Accordingly, the writ petition stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not preclude the petitioner to approach the competent court of civil jurisdiction if so advised, seeking the reliefs as have been sought for in the present proceedings.
Case matter as put over file
And
this
the
and then deal with the whole society.
We think the petitioner is not
For which no steps by way of this.
we are waiting for response number 6.
I have only a few today, man. Already filed.
We appear for response number 6. What is the case about?
I'm selling settlement of respect of 5 minor. On the ground that minor they.
Respondent number 5. Challenging the settlement.
Respect of 5 minor.
What is the ground?
Main ground is the minor, the member of the shareholder of the office particular who was defined minor and is the defaulter minor. And in the tender condition, the defaulter minor cannot. That ground and the minor and reply.
They have it in the year 2029.
So, well, by all the 10 days of time. Reply.
2022, he has got, let him enjoy for another 4 years. 4 years before.
That was for 7 years.
So therefore, I'm having it on 2029.
Within 10 days, they will also fix a debt matter. The buy minor to long. There is observation by order dated 4/2020.
When did you file the reply? Date. It has been submitted by Mr. T. Monto, the learned counsel appearing, senior counsel appearing for the respondent number 5. That the affidavit in opposition has been filed today on behalf of the respondent number 5. We are not filing. Does it take 3 years to get your instruction? 2 years? Huh? Then cost. Huh? You file your affidavit without fail, else cost upon Mr. P. Sharma, 50,000, huh? Mr. N. Bora, appearing on behalf of the petitioner, submits that he would like to file a reply. Mr. P. Sharma also submits that the affidavit would be filed on behalf of the respondent, on behalf of the Fishery Department, on behalf of the AFDC, on or before the next day. Mr. N. Bora expresses urgency in the matter, taking into account that already 4 years have passed by. Pursuant to a settlement, illegal settlement have been made in favor of the respondent number 5. Taking into account the above, lists this matter on 4th of June 2026 at 2 p.m. for final disposal. In the meantime, the respondent's AFDC shall bring on record its stand on or before 22nd of May 2026. The respondent AFDC shall also produce the records on the next date of the impugned settlement. The petitioner would be at liberty to bring on record its stand by filing the affidavit on or before 28th of May 2026.
You are to file by 22nd, huh? May. তাতে লিখিব 22nd of May, petitioner at liberty to file their reply there against on or before the next date. As regards the affidavit to be filed by the petition, affidavit in reply to the affidavit in opposition filed by respondent number 5, the petitioner shall file the same on or before 28th of May. Records you produce it next date. Yes, Ms. Vivora.
That's it, in this case, but some clarification is required on their part. Which may be done. In this case, director approval is necessary. In this case, director is the major one.
Director is a non-payment of dues. The non-payment of dues for 2 years is too much. Verify and pay. What is this construction business? No, not necessary. Verify and pay within 6 months. Dispose.
Number 3 and 4. Thank you. Last time it was directed to lead the executive, persons of NECON. Right. Actually, this is the case of non-payment law, not the bills law. So,
Non-payment of bills.
dues law.
Yes, Mr. Kera, why you are not paying?
My lord, our stand is, my lord, we never had a contract with the petitioner here in my lord. The privity of contract is between Nikon and us. Nikon had employed them ahead, my lord. Now,
What? Can't get you.
my lord, I'll try that.
Who is appearing for Nikon? What, he is entitled to them?
My lord, am I audible?
That man, I need to see pictures. Go and file the affidavit.
Okay, activity for the power grid law.
What do they say?
They say, Lordship, there is no privity of contract. But Lordship, in a very recent judgment, it's a writ appeal. Similar writ appeal decided by the London High Court. The position has been clearly explained, Lord, whether privity of contract applies in case of an MSME or not. Lord. Because we are an MSME law. We are a registered MSME.
What?
In case of an MSME, Lordship, whether the matter of privity of contract it applies or not. Because ultimately, Lordship, Power Grid are the main buyers of our goods, Lord.
Then buyers means?
Buyer means they have purchased the goods through a subcontractor, Lord.
Who are you?
Lordship, I am the supplier, Lordship.
You supply to Power Grid.
Supplied to Nikon, who in turn supplied to Power Grid. But Lordship, there was a contract between the three of us, Lord. Power Grid actually verified, tested our goods. Only then it was accepted, Lord. And Lordship, Power Grid has also made direct payments to us, Lord.
What is this judgment?
My lord, the times when we made direct payment, my lord, were the times when Nikon had specifically given us in writing to make the direct payment.
Lordship, it's rate appeal 330 of 2023, Lordship. The learned bench, Lordship, in the method very beautifully and clearly explained.
But this judgment is different. It is you with any DCL.
Yes, Lordship. It is the judgment, Lord.
How is it relevant? What you will pay Power Grid?
It's a similar matter, Lordship.
How?
Lordship, saying in this case, Lordship, the goods were supplied, but the subcontractor he absconded, Lord.
The contractor.
The subcontractor, Lord. In our case, Lordship, Nikon is the subcontractor. But the main goods were supplied to Power Grid, Lord.
Who is the person who is purchasing?
Power Grid, Lord.
So purchasing from whom?
Purchasing from us, Lord. To Nikon.
Where's your contract?
Contract is there, Lord. And Lordship, the thing is that, Lordship, they have also verified.
No, where's your contract with Power Grid?
Where?
But there is no direct contract law, direct written contract law, but there are minutes of meeting law, held between power grid, Necon and us law. Regarding the delivery and the receipt of the goods law, regarding the testing of the goods law.
So therefore, your contractor is Nikon.
So Lordship, we have received payment, power grid is the
Your
ultimate.
contractor, the contractor will be given to Nikon.
Lordship, they are the subcontractor, Lord.
They are not you are the subcontractor.
Lordship, we are the suppliers, Lordship. We are the suppliers and they are
The
the
suppliers to whom?
suppliers to power grid, Lord.
Show me there, where is the supplier going? Where is the supplier going?
They are direct supply agreement, Lordship, but they are the one who take over the goods, Lord. They are the ones, Lordship.
So what? How does it matter? Who has asked you to supply?
Lordship, Necon.
Therefore, fact, only it is Nikon.
Lordship, that is,
Nikon has asked you to make the supply.
Lordship.
So therefore, you are a subcontractor. Nikon is the contractor.
Yes, Lordship.
Why you not understanding?
But Lordship, we have been receiving payments from power grid, Lordship.
So what? You are receiving payment from power grid. Power grid directly paying you. Now Nikon is no longer there.
Lordship, Nikon is there, but they are not. I mean, they are not fulfilling the terms of the agreement. Lord. They are not paying.
Contract, you are an MSME fighting out before the MSME Act.
Lordship, there are the. I mean, there is a portal called Samadhan. Lord. But for Lordship entering into the Samadhan portal, Lordship, there are some problems because of which, Lordship, because our bills are recent, Lord, could not enter into their Samadhan.
What is the problem?
Their bills, they were asking Lordship bills from before 2016. That's the issue, Lord.
And why will they ask you before 2016? You think for which period? You have a contract with which one? Hirogruti Vaya with Dimple Borua.
It's HP Engineering. HP Engineering Services.
Your contract with Nikon is where?
As of now, Lordship, direct contact is not there, but they are the one, Lordship, who test and approve our goods, Lord. They also make direct payments to us, Lord. I may read, Lord, in Retail 330, the special.
No. Going back. You do one thing, get a dismissal from the court, go and union benches are very clear. They are very considerate judges. They will let you out. What do you say, Mr. Kaya?
My lord,
You fight it out there. In the division bench.
my lord, the judgment by the apex court, my lord, in SR Oil versus Hindustan Shipyard has made it very clear, my lord. Since there is no
I can't
previous,
hear you. So the division bench can hear you. They have better sound system.
my lord, can the
So
matter
that
be
would
fixed for
come.
29th, my lord? I'll personally be there.
These type of cases, we cannot allow. Page 66, serial number 2, we have already accepted. Page 66, serial number 66. We at the MSB already initiated a complaint in MSB Patel against Power Grid in Nikon regarding non-receipt of the Then? Yeah.
Why should we entertain this resolution? When you have a good alternative remedy under 16. Can you make this? Or was it a threat?
No, we are an MSME lordship. We have supplied that good.
Was it a threat that you have gone to this MSME portal?
No, lordship, we went to the MSME portal, but our payer was checked. We are not allowed.
Where? By the way, tell me, if Nikon has anything to do with Amol Borua?
I mean, sir, what paragraph? Page 6, lordship, paragraph 7.
No. What do you say about the answer to 66?
That is what that.
No. Where is it? Rejected? There will be some rejection on letter. Where is it?
Actually, lordship could not file before the Samadhan
Who
policy.
said it? Therefore, I'm asking you, was it a threat? Because there is always a threat. No, I mean, MSME. Oh, be careful. 45 days if you don't pay, then the interest will be charged at 3 times.
Trade lordship, actually, we went to the MSME.
But there's nothing. You say that you have initiated a complaint. Why should we intervene? And why? Go there before the you are statutorily entitled. Go there before the MSP or not before the civil court. But you are entitled. Why should we look into all those things? So this is
One more time if I can.
petitioner hearing claiming certain amounts from the respondent number. The respondent number 3 and 4. On account of certain supplies being made to the respondent number 3 to the respondent number 4. To respondent 1 and 2 through respondent 3. To respondent number 1 and 2 to respondent number 3 and 4. The respondent number 1 and 2 have filed an affidavit stating inter alia that they have no privity of contract with the petitioner. Inasmuch as the contract was only with the respondent number 3 and 4. Mr. H.K. Sharma, the learned counsel is hearing on behalf of the respondent number 3 and 4 submitted. That on one hand, the petitioner on its own have mentioned that they have initiated a complaint in the MSME portal against the respondent numbers, against all the respondents regarding non-receipt of payment, as would be evident from page number 66 of the petition. And more particularly, the email dated 17th of February 2024, and on the other hand, have approached this court. And as such, it is a complete agreement to the process of the court. Mr. So-and-so, who appears on behalf of the petitioner, submits that you obtain necessary instruction and, if necessary, file an additional affidavit. This matter again on 10th of June 2026. In the meantime, the respondent number 3 and 4 shall bring on record their stand by filing the affidavits on or before 29th of May 2026. Petitioner would be at liberty to file reply thereagainst on or before the next day. The petitioner would also be at liberty to bring on record the additional affidavit on or before 1st of June 2026. But the judgment made.
Highly obliged, my lord.
By executive level. Nine. 5,79,000. Remaining amount.
Okay, and has appeared on behalf of the petitioner on call. This court have, the petitioner hearing has filed the instant with petition claiming an amount of rupees 1,42,908. The Water Resource Department have filed an affidavit in opposition categorically mentioning at paragraph number 8 and 9 that the total bill to which the petitioner was entitled to was 6,68,488. And out of that said amount, an amount of 5,79,712 has already been paid to the petitioner. The remaining amount of 88,776 remains payable to the petitioner, but the said amount has to be paid from the central assistance, which the Ministry of Jal Shakti Union of India have not released. This court further takes note of that the petitioner have not appeared before this court on the earlier occasion as well as today. It appears that the petitioner would not like want to further pursue with the instant proceeding. And in absence of the petitioner, and in absence of the Ministry of Jal Shakti, the instant proceedings cannot be proceeded with. Considering the above, this court, therefore, dismisses the instant petition for non-prosecution. What is the matter about? Vice Chairman, violation of which clause? What about the service? Service is complete. Service is complete.
Municipal Court access to APS council.
You were chairman. You've been removed. What is the word? Now, what is your ground? No, one is first filter. Immediately on what you are called to filter, he also participated to the participate on second. Who is the defaulter? Huh? Lok Setia was the defaulter. Yes. And he participated. And how many votes you have lost it? There are 17 members. Was distributed among the 11 attended board commissioners by issuing a due manner by entering the name and obtaining the signature. 11 members casted the secret votes and after casting the due receipt. I made sure the ballot was open and the president found that all 11 numbers of votes were casted by favor of the motion. The counting of the president of the meeting declared the meeting on again was declared unanimously 11 to 0. Then how does it happen? Here also the some are not this is before this other legal every officer not
Commissioner, what commissioner?
Huh?
And it is one also the last.
Who? He's there. Then he didn't vote. No, somebody has to be there. Executive officer has to take over the notes. Executive officer is the person concerned. He does everything. That case. Ulok Setia became, and he was a defaulter. Huh? You did not participate in that meeting, which was held on 8/11. Then you should have participated. You don't participate, you should do. Don't point out that he is a year, then why you are off the line coming out here? No. That case. We dismiss. No. That case. Hello. Special meeting to be convened under 43. The 10 numbers of we have lost confidence upon you and to be a majority of special meetings under 43. Therefore, kindly arrange for special meeting, give you a change. That is to you. 1410. It is being held. 17 members were others were not invited. And these are notice of the given to 18 members. Yes. Right? 10 members, what the meeting also had convened and then could decide the matter. Other members are not invited, only the post then. The notice of the special meeting is being given? Yes, definitely. In the meeting matter, today I give the notice for convenience. Tomorrow I may give the date for meeting. Right. But other members, all the members have to go, they have to issue the notice. Yeah. This notice at page 29 is being issued to by 18 persons. And that who were present is here, na, page, they have signed it. Page, this one. Particular document at page 31. Yes, 31. These 10 members were all these people who were there. So 11 votes are against you. How many votes is required? Quorum is how much? More than half. Then 11 is there. No, 11 were there, voted against you. No, 11 members were there who casted the vote. Obviously. No, here there were already 11 members. Kindly see the members who were present in the meeting. One vice chairman is there. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Executive member did not cast a vote. Also not invited to meeting. They couldn't be invited to meeting. Why?
Anyways, he's not there, so you are in luck. Mr. S.R. Volva, appearing on behalf of the state respondent, submits that the Tinsukia Municipal Board is being represented by Mr. S.S. Roy. However, his name has not been reflected in the post list. So taking into account the above, this matter again on 18th of May 2026. In the meantime, for admission, Mr. S.S. Roy, the registry shall show the name of Mr. S.S. Roy in the post list. Mr. S.S. Roy shall also, on the next day, produce the records of the impugned minutes, the records pertaining which led to the resolutions dated 6/11/2024, as well as 8/11/2024, which have been impugned in the instant proceedings. What is this? One payment. Verify and pay. 6 months. Yes.
Apologies, my lord, for the.
The last item. Okay, we have time till 2:45.
My lord, in 42, I've been recently been engaged in this matter and in 42. And my learned senior friend for the FCI has intimated that they have not received a copy of the petition. Though, my lord, there has been a counter affidavit filed by the union and I have also filed a reply to this matter. Can it be taken up in some level after some?
What is the matter about? Why the matters are together?
My lord,
Who is not together? What is-
41, 41, my lord.
Is the matter before any other bench? Huh? Okay, let us first try 41. What is the matter about? Mr. D. Rathi, you are,
Yes, my lord.
okay, why?
My
You
lord,
are there from 5/1/2026.
yes.
So you are not new here.
In 42, I'm new, my lord.
Okay, let us first have 41. Again,
Yes, my lord, the matter pertains to illegal collection of the penal damage charges by the.
that day I took up.
No, that one is a different one, my lord. That is totally a different matter, my lord.
I know that. That is what I do.
My lord, that was terminal charge, this is penal damage charge. Exactly. That matter was terminal charge, and this is penal damage charge, punitive in nature, penalty.
Huh?
It's my lord, penalty in nature, punitive. My
Yeah.
lord, there is a coordinate being judgment of our Honorable High Court, which is stating that the matter was remanded back to the learned tribunal in respect to claim for penal damage charges. The judgment which is placed by my learned senior friend, my lord, however, the facts are totally different, my lord.
What is the charge here?
Penal damage charges, my lord.
Not for, huh?
In this matter, my lord, 13 lakh.
Yeah, the PA I put to challenge the imposition of penal demerit charges and terminal charge by the parent. Terminal charge is out.
Yes, my lord, I am not pressing into it, my lord, only in respect to penal damage charges.
And here at paragraph 28, it says the respondent failed to show cause that the final has been demanded after wide publicity and notice of the impartial. The consider obtaining the grievance rate of not adhering to the review circular of not providing 48 hours notice after wide publication and so on. The same is within the confines of 36. Within the jurisdiction of the in our view that so this covered
My lord, facts of that matter and this matter is also different. My
That
lord,
is-
I
that
also,
is
my
the
lord,
difference.
section 13 was not placed before the learned single bench at that point of time. Section 13, my lord. Learned tribunal, my lord, jurisdiction of the learned tribunal is very limited. It is only in respect to granting compensation for the loss, destruction, damage, deterioration, if the lordship will look upon section 13. However, my lord, penal damage charges is punitive in nature. It's a penalty imposed by the railway authorities.
Is it done under 73?
No, my lord, it's totally a different concept brought by the railway authority, penal damage charges. My lord, before there was a concept of damage charges, before 2008, my lord, the railway can impose 150 rupees per hour per wagon, my lord. However, my lord, in 2008, there is a circular brought by the railway, according to which railway can impose 4 times, 6 times, 3 times, as per their convenience, my lord. Railway can impose those penal damage charges. But the mandatory prerequisite is 48-hour prior notice and to conduct a white publicity. In a similar angle, my lord, our a writ petition was filed before the Honorable Gauhati High Court, article judgment, my lord. In that judgment, the learned, our Honorable High Court has allowed the writ petition, stating that the railway has not conducted any kind of a white publicity or 48-hour prior notice. Uh, But today I was not expecting since there was not there was my lord, today I have not read the judgment, and today my lord, the FCI matter was not that far.
FCI is different.
Yes.
Railway.
My lord, it was connected. Since it was connected, my lord, any other day, my lord, I'll argue this matter. I am confident, my lord, I'll argue.
Paragraph. In paragraph 15 of the petition.
In FCA, it's 2 crore 40 lakhs, and this one is 30 lakhs.
In paragraph 15 of the petition. In paragraph 6 of the judgment, then you should, it's a covered judgment. Paragraph 15 of the petition, one of the challenges against the collection of penal damage charges was an illegal one, and the respondent will be directed to refund 1426 million. There are specialized councils for railway, huh? I mean, who could do that, and Madam M. They're specialized in this. Another one was there. Nowadays, I think he doesn't care. So there's a lot of matters right there. AK, what is his name?
Will
There's another one. He used to do much. They are in the same chamber. But same chamber.
though I'm not associated.
So they have the monopoly.
I'm just associated with my senior Mr. K.T. Maheshwar, my lord. But I'm with M. Sharma, I'm not connected. My lord.
He's now become a railway member.
No, my lord. He's no, my lord. He's still practicing.
Okay. I had the occasion of hearing him in one matter. Into the delay. There was a lot of teams which were dismissed on the grounds of no delinquency application by station. But the grounds which were there under no circumstances and all were dismissed out there. But it's the H. Gupta, the learned counsel appearing, learned CC appearing on behalf of the respondents, submits that the issue involved in the instant proceeding is squarely covered by a judgment passed by the learned coordinate bench dated 29/1/2025 in the petition number 7096 of 2021. Wherein it has been categorically held that the railway tribunal would have the jurisdiction in respect to entertaining any claim pertaining to the penal/demurrage charges. Per contra, Mr. Gauhati, the learned counsel appearing on behalf of the railway petitioner, submits that there are other coordinate benches of this court who have held that this court would have the jurisdiction. However, he said that he has not brought the present safe judgments before this court today. Taking into account the above, this matter again on 8, you will be able to get it on 11. I'll give you another 3 days. On 11th of May 2026.
If possible, my lord, 11 days, I am having some other.
How about the unlucky 13?
I'll make it lucky, my lord.
13th of May 2006.
What hope?
Yes, now come to 42. This court, however, finds it very pertinent to observe that the issue involving deputation number 4899, in the present petition with that of deputation number 6678 of 2024 are different. And as such, WPC number 6678 of 2024 is detached from the present petition. Basically shall accordingly. Now come to the next 42.
In 42, my lord, I am the contractor, subcontractor. In Privity, FCI, my lord. My duty is to transport the consignment from the railway siding to the Food Corporation of India, depot, my lord. Herein, my lord, the railway has again imposed the penal damage charges upon the Food Corporation of India. Food Corporation of India has paid the penal damage charges. Now, Food Corporation of India has deducted to that amount 2 crore 40 lakhs from my work permit, my lord. And my lord, under as per section 74 of the Railways Act, either consigner, consignee, or endorsee can oppose to the railway claims. I am neither of them, and I have to bear with this illegal collection, my lord. Railway has not conducted 48-hour trial.
Were you not the transporter?
My lord, I am the transporter as a third party, my lord. In the consigner, in the all the railway receive the consigner.
No, you are the consignee. Consignor. We do.
Both are FCI, my lord. Both are FCI.
No,
Consigner
no,
and
but
consignor.
on behalf of the FCI, you are carrying out the transportation.
Yes, my lord.
That means you are the person concerned.
Deliveries are accepted by the FCI authority, my lord. And as on paper,
See, I understand so far as regards demand charges is you keep a particular container out there in whole, thereby affecting the particular traffic. Yes, that's the reason why it is being done. Now, you must have, you were the person concerned who have got it and you did not, who was to download it? Just take out the goods from there.
my lord,
Whose responsibility?
my
Was it
respons-
exciting?
my responsibility is to unload the goods from the wagon and to carry it to the FCI depot, to the Food Corporation of India, go down. That is my work, my lord.
And if there is a delay in unloading of the vehicle and there delay, so the railways impose the charges for the delay, impose charges upon the FCI, and then FCI pay it and thereafter impose the.
Okay, now the thing is, who are FCI?
I am FCI.
The railway partner?
Yes, my lord.
Where?
So when
No, no, first and foremost, tell me, why is the railway wrong?
my lord, railways have not given 48-hour prior notice and conducted right public for imposing penal damage charge, which is the
So therefore, you now say you have nothing, no claim against the FCI. Because the FCI, you have made him a performer.
yes, yes.
So now therefore you say there was 38 hours notice. We have filed the affidavit in approval. You filed your reply.
Yes, my lord. The railway have filed, we have filed our reply.
When did you file your reply?
Fifth of January 2026.
Huh?
5th January 2026.
12 January.
5 January.
You filed. It's not on record.
My lord, that time I was not engaged. I've been newly engaged. This matter has been filed by some other firm.
But it is not on record. It is not on record. And you have not given him a copy also.
Emails be engaged in email may also be directed to serve a copy of their affidavit. Right?
He has put you as performer. That means he has accepted your actions. You should be happy.
Yes,
Isn't it? You have accepted his offer. You have no claim against him.
no, I think this is the-
Isn't it? The moment you are making him a performer, you have no claim against him. You have any claim against the FCA?
My lord, the railway has imposed, illegally imposed that.
So therefore, your case is only against railway, not against the FCA.
Yes, this is my.
Railway, you have filed your reply. Yes. But it is not in report. Mr. T. Rafi, the learned counsel appearing on behalf of the respondents, the petitioner submits that the petitioner had filed an affidavit in reply to the affidavit in opposition filed by the respondent numbers 1 to 4. The said affidavit was filed on 5/1/2026. However, the same is not on record. The registry shall is directed to list the instant petition again on 15th of May 2026. Along with the said affidavit in opposition, a reply filed by the petitioner on 5/1/2026. You have no claim against him.
Yes, fine.